This isn't coming in. What's next?
2277-451.
451. What is this?
This is another risk management note discussing the theorizing of the hospital that rather than lesions, these were self-inflicted scratches. And here it's discussed that this was a trap set for Dr. Major.
There's no predicate laid, there's no foundation laid, we don't know who wrote it, it's somebody's thoughts, we don't know who that person is, if they have any authority to speak for the hospital.
This is in the risk management file, right?
It is in
Yes.
the risk management box, that's correct.
Here's my problem. I mean, I know that the Hill Ward Henderson firm was intimately involved with everything that was going on at this time. It's kind of difficult to understand how we keep getting, we don't know who this is or what this is. It just is difficult for me to understand how we're 5 years into this after the fact, and we still, people are saying, I don't know what this note is, when
Judge,
when Mr. Shapiro and Mr. Hunter were there.
Yeah, I don't mean to push you back hard on this, but Your Honor, the involvement of myself and Mr. Hunter was on tangential issues on occasion when the hospital would, without breaching attorney-client privilege, call us and ask us to weigh in on something that was going on. But neither Mr. Hunter nor I were intimately involved in every aspect of it.
And I'm not saying that you had any information about this specific note. It's
Right.
just, I mean, it's just difficult for me to continue to hear the argument that we don't know anything about this.
Judge, this file was produced after certain former risk management personnel were deposed. These particular writings have never been identified as to who wrote them, what the context was, or what the purpose behind that context was. So, I mean, I've got a choice. I can either make something up to tell you that I don't know, or I can tell you the truth, and that is that we don't know what the specific context of these writings were. And in some of these cases, I don't know who wrote them. None of the people who were in the risk management department, literally none, are there anymore. Some of them aren't even in the state anymore. So, I mean, I can't conjure up information that I don't have.
It would seem, though, that it's a note that a risk management person, apparently unidentified, took on presumably December 30th, 2016. And, you know, I don't see why it's not relevant to this cause of action.
Well, it seems also you made a note regarding a potential claim that's being made, and why isn't that an internal note regarding the claims that are being made? Why is that relevant or even admissible?
Why is risk management participating in the medical care of a child?
With all due respect, Your Honor, that does not indicate participation in medical care. That indicates that someone has told risk management something that they've written down. That's all.
And isn't there been testimony that these scratches is a symptom of CRPS that the hospital was billing for?
There are lesions, certain types of lesions that can be symptoms of CRPS. They are sometimes confused with other skin lesions, eczema, scratches, other types of things. There's a whole host of things like that. I know that when this happened, when this notation got made, there was concern that some of the lesions that were observed were self-inflicted. That's all this says. But it doesn't show, and I think the court needs to understand what it doesn't show. It doesn't show, unless one speculates about it, it does not show that risk management was taking any active role in patient care. It shows that someone expressed to risk management a concern. That's all it shows.
That a 10 or 11-year-old girl is trying to create a trap by possibly scratching her. So look, it seems highly relevant, and the discussion, even though apparently the defense in 5 years, even though they were involved at the time this was created, doesn't know who it is, it still is relevant. It still is a statement against the interest of the hospital, and it will come in. So what number is this?
It was 2277-451, Your Honor.
What's next?
There's several policies at the bottom there, but I'm going to skip those for now in the interest of time. I'm going to move to the first page. We're at Exhibit 2278, pages 036 to 37.
2278.
I don't see that on the first page.
I don't see it either.
First page, third from the bottom.
So
It's on the second
36 to
page.
37.
I think it's on the second page, Judge.
Didn't you say 36?
Yeah,
I must be on a different
I
list.
think you have the
than
list from yesterday. That's okay. I can adjust. Yeah, second page, second from the top, 2278-36 to 37.
What?
This is
Oh.
the corrective action notice. The corrective action notice of Catherine Beatty. It's been discussed at some length. Highly relevant. At the time, her anger management issues during Maya's hospitalization.
You want to take this outside.
Hearsay. 9403. It's already been discussed and testified to.
these are. Mr. Whitney, tell me about hearsay exceptions.
I think you were going to say statements against interest, Your Honor. It's also a business record, party admission.
Yeah, Judge, also relevance, I'm not sure what, there's no negligent hiring for Kathy, there's no negligent retention for Kathy Beatty.
No training after this.
Court's gonna go ahead and admit 2278-036 and 037 over the defense's objection. What's next?
2123, pages 639 to 642.
I'm sorry, say again, please.
Yes, ma'am. 2123, pages 639 to 642. On the list that everyone else is looking at but me, it's on the first page, 4 cells down.
What is this?
Internal email.
This is. We withdraw this, Your Honor.
Yeah.
What's next?
Yeah. Uh, 2123-495.
Judge, my objection was it needed 496 for completeness and perspective.
Can I see 496 as well? Haven't I already seen this one?
Honestly, don't remember.
I don't
Judge.
believe so. I think there's been testimony in her deposition about the massive update.
It's familiar to me, Your Honor. But
this has to come in too.
Hey, Judge, we're not objecting, to be clear, but we think for perspective, 496 also needs to be admitted as
Any
opposed to the
problems with
sheet
four nine six coming in?
out
No,
of
Your Honor.
nowhere.
So the court received 2123, 495, and 496. What's next?
All right, now I'm going to drop back to the risk management file. There are a couple of policies that exist within the risk management file. And so I'm at pages 2277, then 280 to 285. It's a consent policy.
280 to 285?
Yes, 280 through 285.
What are these policies?
These are Johns Hopkins internal policies effective at the time. You can see the effective date of March 11, 2016. It says to do with specifically consent to treatment within the hospital.
Well,
It's determining legal guardian, sorry, Judge.
why is this not really muted out by a court order?
Thank you.
Because, Your Honor, the parents, Jack and Beata, retained medical decision-making power under the court order. And so this policy spells out how the hospital is to address their consent to treatment during the time. And we have an issue over the hospital claiming that the 3 or 4 page consent form signed at the beginning of hospitalization provided blanket consent for the entire hospitalization.
This is talking about documentation of guardianship.
I can show you on the second page. Here we are. Court ordered guidelines number 2 here on the third page. If you look at Roman numeral 2 under here, parents consent, DCF sheltered, it discusses specifically how to operate in this environment where a child is sheltered within the hospital, and it spells out that despite the child being sheltered there, the parents still have rights to consent, and it further spells out that if the parents do not consent and they move forward with some treatment without the consent, it has to be documented in a certain way. And those entries are absent from the medical record. So we need this to show that they did not actually have consent under that consent form. Scroll down a little bit more for me. If you look at the third bullet point there, Your Honor, says, the minor child's medical record should reflect, and it lays out 1, 2, 3 different things that it needs to lay out if they proceed without parental consent for alleged treatment.
What I want is I want a printout of this document. I'm going to reserve on this, but let me hear your argument, and I'll try to get a ruling by Monday. I'm going to have to look at this one more.
Well, Judge, frankly, I think I have to look at it a little more carefully too, but my concerns are, this is a document, I'm not sure if it exactly is apropos to the particular orders we have in this case, particular situation with our DCF hearing. I would like to look at it closer as well.
Yeah, okay. Can someone just get me a physical printed out copy so that I can take it home with me over the weekend?
Yes, Your Honor.
Thank you.
Okay.
What's next?
Next is same 2277, same exhibit number, then pages 289 to 291. It's the risk management policy in effect at the time. You can see the effective date of February 18th, 2016. And it discusses responsibilities of the risk management department and the risk management committee, highly relevant to this action.
So this is just general risk management. Does this have any reference to dependency courts or DCF or anything like that?
In my review, I don't believe so. I'm 90% confident of that. If the court would like to review over the weekend to
Well-
verify.
And Judge, what's the relevance of this policy to the allegations in this complaint?
I'll take a copy of Exhibit 2277, pages 289 through, where does it end?
291.
291. I'll take that home with me over the weekend as well.
Next is 2277, pages.
Let me ask you this. Were we thinking about finishing at 3:30, 4 o'clock, and maybe we can,
Yeah, we're getting very close, but yes.
why don't we stop and then start with the jury since we're now past 1:45.
Yep.
Let's bring in the jury.
All rise. Through entry.
Okay. There we go. Everyone, please be seated. I loved how you came out in a little different order. You're trying to see if I'm keeping track, huh? Yeah, I appreciate it, members of the jury. I want to confirm that while you're away, you did not discuss this case amongst yourselves, you did no investigation, you did not receive any information. Is that all correct? Correct. And that no one has approached you about this case since you were last with us. Is that correct? Correct. And have you seen any media coverage since the last time we were together? No. ESPN? Well, I know we were just kind of joking around, but I just want to be serious. No one has seen any media coverage about this case. Is that correct? No. Okay. We don't need to talk about the Rays or anything like that. So, okay. Mr. Anderson.
Please call Robert Trent.
Stand here, face the court, raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Please state your name for the record.
Hi, I'm Robert Paul Trump Jr.
And have you been called as an expert in vocational rehabilitation to discuss the diminished earning capacity of Maya Kowalski as a result of the actions of Johns Hopkins?
Yes, sir, that's correct.
To give the jury some background here, will you please go through your background training and experience towards offering them? You know what? Strike it. What does a vocational rehabilitation expert do first?
Certainly. So in vocational rehabilitation, keyword rehab, and when we have the word vocational involved, that means work. And when there's been an onset of an injury or a disability or an alteration to your life, how is your job now going to be impacted? So for a quick example, if we have a concrete worker who then becomes a spinal cord injured patient, you're going to go, gosh, it's kind of hard to do concrete work as a spinal cord injury or in a wheelchair, that kind of thing. So what can you do now? How can we rehabilitate you from a vocational and job standpoint?
And can you give the jury the benefit of your background training and experience towards offering those opinions?
Certainly. So I have an undergraduate degree from Michigan State University. I then went on to the University of Arizona in Tucson to earn a master's degree in special education and rehabilitation counseling. From there, I went to the University of Florida, Gators. I don't know if there's Seminoles fans here, but then I took some coursework there after my graduate degree in life care planning. I took 2 national board certifications. One is in rehabilitation counseling, which I just talked about with regard to rehab and counsel people on how your life has changed, and then board certification in life care planning.
And what licenses, and so, did you just tell us the licenses and certifications you hold?
I did, the 2 national board certifications, yes, sir.
Oh, so behind your name there is an MA, a CRC, and a CLCP. And what are those again?
That's correct. So the Master of Arts, and then the CRC is Certified Rehabilitation Counselor, and the CLCP is Certified Life Care Planning. And life care planning is future care needs, and I think someone else is going to talk about that today as well.
Okay, and do your input then go into a life care plan, in this instance, the life care plan prepared by Dr. Bifulco?
That's correct.
All right. So let's talk a little bit about your assignment in this case. Can you tell the jury what you were assigned to do in relationship to the Kowalskis?
Certainly. So I was asked to read the records, speak with Mr. Kowalski and Maya as well. I did that several occasions. And then to look at all the evidence and develop what Maya's future is going to look like from a school standpoint and from a work standpoint, and also a future care standpoint. It's very important that there is a life care plan involved here, which is going to actually help her, and that came into my decision-making as well.
So you have then had interviews of Maya and her father, and then reviewed, what else? Have you reviewed medical records, or what do you review it?
Yeah, I reviewed thousands of pages of medical records, deposition testimonies, spoke to several experts in this matter to get a really good idea as to what the future does look like for her. We always work on a team basis, so we incorporate a lot of collateral source information from other providers. So we have a really good understanding as to how to formulate the future and the treatment plans that we develop for her. We just can't do it alone or just impulsively. We do need to reach out and do some due diligence and see what's really going on here.
So what, if anything, was significant about Maya Kowalski's diagnoses as it affected the opinion you will offer?
Well, we have PTSD. I talked to Dr. Brewerton at length about that, and I also talked to Dr. Kirkpatrick and others about the CRPS, and I think by this time the jury's probably heard a lot about both. So to have a quick answer, those 2 diagnoses is what we're looking at for long-term future care.
And is there an interplay between those 2? I don't expect you to get into the medical opinions, but from the vocational rehabilitation standpoint, are the combination of these significant?
Yes, we try to look to see how the patient, in any case, our spinal cord injured patient, for example, how do we get them better? What does their prognosis look like? And in this case, when we have the complex regional pain syndrome coupled with the post-traumatic stress disorder, especially at the age of onset with PTSD, where Dr. Kirkpatrick talked about our neurotransmitters, as our brain is developing, we have different pathways as we develop. And so when there's trauma that happens at a young age, you're going to develop in a much different way and trajectory than you would have had the onset happen after your brain is fully developed. So we have a rather perfect storm here because CRPS is anxiety-ridden, it's pain-ridden, it's emotional, it's the unknown. Gosh, when is the next flare-up going to happen? Then we also have the PTSD issue coupled with that, and it just goes around and around, and they chase each other. And so it's a very, very difficult and very guarded prognosis for the future.
All right. So when we look at the vocational damages here, did you apply any particular statistics? And if so, explain how and the source of the statistics.
I did. I'm going to do my glasses on and off. I was playing basketball with my daughter over the weekend, and my regular glasses were broke. So I'm going to try my best here with these Walgreens glasses. So I looked, nothing wrong with Walgreens, they're very good glasses. So I looked at government data to see what we would look like for her based on the trajectory that she was on as a student, as a young child. We've all heard how well she does in school, piano, figure skating, Polish as a second language, her being recruited by Duke University at a very, very young age. She's almost done with an AA degree. So she's doing very well academically, but that doesn't tell the whole story. And the whole story is that, as we've heard and we know, what's life going to look like when she leaves the house, if she can leave the house. And so I looked at the trajectory she was on and her wages at the doctoral level. I know Ms. Kirby talked about some of the data that I use, the data that I have to use within my methodology, is that she no doubt would have been at the professional degree to a doctoral degree easily. I don't think anybody ever refute the fact that she was on that track from birth, right? She was just a freight train going towards college. There's no worry there. And so I looked at the wage data for that at the $1,883 in 2019 dollars as a weekly wage for that. It's basically the maximum based on the government data.
And what does that come out to annually?
It comes out to the 97,000 range that Ms. Kirby talked about, and then the 108 that she annualized.
All right. And so that seems a little, isn't that low for someone with her potential?
Yeah, and so again, the methodology that we're bound by as voc rehab counselors is what does, the government analyzes all of our jobs, right, across the board, and they come up with median statistics and based on educational level of attainment and other types of areas. And so really that's everybody piled in, and Maya is an extreme outlier, no doubt. I looked into other data. For example, the government indicated that CEOs across the board are at the $630,000 to $1 million range. I also looked at a study that Ivy League grads make about 38% more than graduates from other colleges. So those wages were coming out of college, that was $86,025. Other colleges, you come out at $58,543. Again, she's recruited by Duke, and there's no doubt in my mind that she would have been on that trajectory. Absolutely.
Right. So for the jury's purposes here, the $97,916 is a statistic that they can then apply their own view of Maya's future or potential to.
Yeah, I mean, that's one way to look at it. And the CEO is, that range is about $391 an hour, all right, at the $830,000 range. If we're going to look at her as a Ivy League grad with this, all A's and being recruited early on and, almost done with a 2-year degree at high school.
So what age did you consider Maya entering the workforce in light of her academics?
Well, now, after everything that's gone on, about age 28.
All right. And then assuming a best case scenario that the other things we're going to talk about don't happen, what would her work-life expectancy be?
65 to 70.
All right. And so then over the course of her life, if you just take the statistics, and we're to these age, was it to age 65 or 70? To age 70?
It was a range, work-life expectancy, age 65 to 70.
All right. And so statistically speaking, her wages prior to injury at the government standard would be what? In other words, what was her baseline?
Yeah, let me get to it. To age 70, it would have been $3,622,892 or I'm sorry, to age 65, age 70, $4,112,472.
All right. And did this take into account then a control, that is a properly treated and medically controlled CRPS as part of this in the baseline?
Yeah, it does. I had a conversation with Dr. Kirkpatrick and others about if the CRPS had been managed correctly all the way through, there's no interruption. There's literature out there that, as well as the doctors, indicated that very important to get immediate care for CRPS and get on it right then and right now. Any delays can be very, very difficult and make things all the worse. So I asked the doctors, what was her trajectory like if she had...
Experts are allowed to comment on hearsay.
Overruled.
I asked the doctors what would her trajectory have been like if the CRPS was properly managed from the get-go. There was no interruption, no delay, and they all felt very, very good prognosis in there with some interruption for flare-ups, but nothing that would have really taken her out or interfered with her ability to maximize her wages and her full potential. They all felt very, very strongly about that.
All right, and were these opinions based upon your background, training, and experience, and to a reasonable degree of probability within your profession, useful as a baseline for Maya Kowalski with her CRPS, but in a controlled and well-medicated, I don't hate to use that term, but well-taken care of manner?
Yeah, I mean, if her future care needs would have been met properly, that's the idea.
And so, and this is at 97, shade under $98,000 a year?
Yeah, based on the 2019 data, the Economist grew those to 108, and then I spoke about how she's kind of an outlier. So yes.
When you say an outlier there, does she have, based upon your background, training, and experience, the capabilities in light of her intelligence, EQ, that is emotional quotient for presentation, articulation? Does she have the probability of earning considerably more than the government statistic?
100%, absolutely. Again, she was a freight train heading towards college. There was nothing going to stop her to maximize her wages. She had no impediments. The CRPS, yes, but if that was managed, then there was just nothing in the way. Absolutely.
And so then let's talk about post-abuse and trauma earnings. So tell the jury now what you went through to try to figure out Maya as she is now.
Well, the best things that she had going for her was her pre-existing condition. If she had learning disabilities or didn't do well in school, didn't like school, the picture would be much, much worse. But we're going to look at all of her strengths throughout this because I want her to work. I want her to be independent. I want her to get better and live a good, full life. So we're going to try to get Maya through college, try to get her to work in some capacity. But I also have to look at the evidence. The evidence is that, especially with Dr. Kirkpatrick talking about PTSD.
No objection about the hearsay.
PTSD combined with major depressive disorder, combined with the anxiety, the CRPS, then combined with a ticking clock, combined with people that may look like the people from Johns Hopkins, combined with the events that happened with her mother. And there's a study about children.
Object to the bolstering literature.
Sustained.
Just based on your background, training, experience, have you previously followed patients who have had a history of suicide in the family?
Yes.
And in your clinical experience, work experience, what are the concerns there?
Well, there's plenty of data and literature out there that says that parents.
Again, Your Honor, respectfully.
You just have to leave out the literature part.
Sustained.
In my clinical experience, I've had where parents commit suicide. The apple doesn't fall far from the tree, and then the child commits suicide as well. They're beyond a reasonable degree in my clinical experience. Absolutely, it's a big concern.
Now, in this instance, was there any concern, and did you have an opportunity to talk to Dr. Brewerton, a psychiatrist, a pediatric psychiatrist that did the evaluations on Maya?
I did. Yeah.
And so what are the concerns here now with post-traumatic stress disorder insofar as the, I guess you'd call it deviations off of where her brain would have been if she had not experienced this level of trauma?
Well, I talked to, I don't know, someone's phone's ringing over there at the table. Yeah.
This is a good time for everybody to take their phone out and actually make sure their ringer's off.
I apologize.
Not that it isn't a snappy tune.
That was a pretty good ringtone, Mr. Hunter.
I think maybe it was done on purpose to mix me up. I don't know. Yeah, trip me up a little bit. Where were we before the?
We're talking about organic changes caused, based on your consultation with the treating physicians, we're talking about organic changes to the brain as a result of the trauma and the resulting PTSD.
Yeah, and I've worked clinically with trauma patients throughout my whole life, and what Dr. Brewerton told me is really nothing new. When we have, one of the reasons why there's accidental deaths are so high with children is because their brains are still developing. They don't think that riding the car near the road that something could happen, right? And that's why those accidents happen with children all the time. So When we have, and Dr. Kirkpatrick spoke about this, when we have neurobiological changes in our brain as we develop, we take a different road. We go down a different path. We develop differently than we would have had that trauma not occurred. And the issue here is that when this all was occurring, she was a child. There was no escape. She can't go anywhere. As adults, we can get out of the situation, fight or flight. She was captive. And that, with Dr. Kirkpatrick talking to me about that particular thing.
Approach, please.
You were saying that she could not escape. We were talking about Kathy Beatty. She had no way of getting away from her, and that abuse that ended up causing this.
Yeah, I mean, as a 10-year-old child, I mean, I can go on. I think we may have heard a lot about what happened during that, I guess, captivity, you would say.
We don't have to go through that.
Okay, we don't need to go through it again.
They know it. All right. So I want to talk a little bit about the accepted methodologies within your profession that you applied and why you chose them.
Yeah. So how do we know what children are going to do in terms of school in the future, how they're going to grow up and what kind of jobs, what kind of wages, right? They're children. They haven't gotten there yet. So there's what's called a pediatric RAPEL, R-A-P-E-L methodology. And that is an acronym, and PEDS is for pediatrics. RAPEL is rehabilitation, access to the labor market, placeability, earnings, and labor force participation rate, sorry. And the theory is that, again, the apple doesn't fall far from the tree. So if you have two parents with PhDs, kid's going to have a PhD. If you have a parent with a law degree, your child's going to have some sort of master's degree. If you have a child with a 4-year degree and so on, if both parents have high school degrees, statistically speaking, your kids are also going to just have high school degrees and nothing further. Of course, there's outliers on that. There's lots of examples, about what kids do versus their parents, but that's the overall methodology on a statistical basis. So we looked at Beata, the mother, 4-year degree. That's no problem projecting there. Father was a firefighter, and I think he had less than a college degree. We also, though, need to then look at Maya with regard to her uniqueness. Was she a poor student with learning disabilities that might say, well, gosh, she's probably just going to get through high school? It wasn't the case. She's gifted, high IQ, recruited by Duke University at a very young age, participating in college programs, almost done with a 2-year associate's degree. So using that methodology, it's no problem to predict that she, again, was just this academic freight train with limitless possibilities. That's the methodology.
And then did you take into account what was the rehabilitation plan, and where are they going to learn about that?
Well, the reason why I'm hopeful for Maya, and it's guarded, is because we do have a life care plan. I'm also a certified life care planner. And the rehab part is that there's future care needs, counseling, guidance, medications, access to health care in the future for her. And that is meant to, and this is very, very key and very, very crucial, that Life Care Plan is designed to maximize her independence and minimize her complications, right? Well, what are her complications? Her complications are trust, going out into the real world, triggers out there, things as little as a ticking clock to what people wear for jewelry to familiar patrons at a restaurant. And we need to look at that and try to forecast the best situation secondary to that. And that's why that Life Care Plan with Dr. Baifuku is so crucial and important. And that's why I'm hopeful that 50% reduction, I'm hoping she can get the help she needs and get to work, have a good, productive life. Very concerned about child care as well. You know, all those types of things, those life events that we need to get the dysregulation and control of her brain and how she looks at the world and her viewpoint in the entire world. And that's why I'm hopeful that the Life Care Plan will allow her as a vocational person to get her to work, if at all.
Is that why you have 100% disability and then the 50% disability?
It is. So 100% is a total loss of earning capacity.
But that doesn't necessarily mean from day one. It means it could kick in at different times.
It could. I mean, the total loss is really, is she ever going to work? And I hope that's not the case. I really hope that's not the case. I hope that the Life Care Plan works and she can work. I want her to go to work, earn wages. Work is very therapeutic for her. Is she going to get out of the house? Can she get through college? Can she fight off all of the outside sensory that we can't control in our world, right? We can't control other drivers, other coworkers, bosses. We can't control that. So can she get over that and get going on some kind of work? And that's what we're aiming for. The best case scenario is that.
All right, and then you also talked about, and I want to hit the highlights here, and if I'm missing something that is important, let me know in your analysis. But you also talked about placeability. What is that?
Placeability, where is she going to, how will she be placed in the labor market? You know, an easy way to kind of look at that, we have Zoom jobs now, right?
Right.
You know, that's an option. And I've thought about that. You know, can she be a Zoom worker? Might be therapeutic for her, might also not be, because I want her to be out in the world and not have to depend on never leaving the house. So placeability is very key. We all have jobs that you work in public, you work by yourself, you work in a closed environment, open environment. So the placeability is very key for her.
And labor force participation.
Yeah, labor force participation is full-time, part-time. You know, really with my 100% loss is no time, 50% is part-time. You know, and so labor force participation is you know, 2,080 hours a year or 40 hours 40 hours a week.
So you were looking for all of the available options for Maya, given her circumstances?
Yes, sir. Yeah.
All right. And then I wanted to talk a little bit. Let's get the opinion. Do you have an opinion based upon your background, training, and experience, and to a reasonable vocational rehabilitative probability as to the losses more likely than not to be sustained by Maya Kowalski?
I do. Yeah.
All right. And there seems to be, 4 different scenarios? Or
There is, yeah. So
go ahead.
Let me walk through them. So at 100% loss, and that is she never going to work, right? And for reasons I just stated of all of the different barriers and what we call in our world impediments to employment. And those impediments are things I already talked about ad nauseum, and I think that I don't think I need to go over those again, but I think I hit on those. And the high range there to age 65 would be a loss of $3,622,892, or up to age 70, $4,112,472. The best case scenario for her, again, if the Life Care Plan is afforded to her, which is the future care needs, counseling, home care, things that we've already touched upon. If that's afforded to her, the hope is she'll get better, and we want her to get better. We know this is a permanent thing for her. It's lifelong, but there are things out there, there's tools out there that can work and get her better. So the best case scenario for her is to age 65, a 50% reduction in her earning capacity is $1,811,446. To age 70 is $2,056,236.
And we'll have those numbers up in a moment. Now, should the jury decide that Maya's actual earning capacity could be a multiple of this, 2 times, 3 times, 4 times, and based upon your analysis, background, training, and experience, are those within the probabilities that she could earn that or would earn that with the right care?
Yeah, absolutely. Again, my numbers are based on $97,000 a year.
All right.
Right.
So,
And
Go
so,
ahead, please.
so that's the median. That's 50% make higher, 50% make lower of everybody in the governmental study. Big national data. And that's what that's what I'm kind of bound by in terms of methodology. I have to look at government data to support these opinions. Then we look at the individual person. We might go, gosh, does that make sense? Would that person make $97,000 if they had, a severe learning disability, right? So we can look at it from that spectrum. We can also look at it from the other outlier spectrum is, again, and I'll be quick, all A's, Duke University, 2 languages, overachiever. So she would be on the higher outlier of wages for the future.
So let's say the jury did, in their deliberations, come to a conclusion that her abilities would earn a multiple of this. How would they go about using your formula to compute that?
Well,
other than simply doubling or tripling or?
I mean, you can look at it as a times 2, times 3, times 4, times 5 multiplier. I leave that to the jury. That we can do that. As I already indicated before, gosh, there's a 38%, almost 40% difference between Ivy League grads versus non-Ivy League grads. We also know that CEOs on a wide range make $630,000 to $1 million, right? But I leave it to the jury to listen to all the evidence, listen to Maya, listen to everybody, and that is up to you for that.
All right. And so your opinions here, you're not taking into account any what we call human damages, general damages, such as Maya discussed this morning and Jack and Kyle yesterday.
No.
These are simply for the diminished earning capability she'll have.
That's correct.
And again, your opinions here are to a reasonable vocational rehabilitative certainty.
Yeah,
Probability. I should say probability for this. Sorry.
My opinions today are beyond a reasonable degree of vocational probability, based on the methodology, based on my background training experience, based on my numerous conversations with numerous experts. That is true.
Your witness?
Good afternoon.
Hi there.
Let's get the fun stuff out of the way first. What do you charge to be here today?
Well, I'm not sure about your characterization of fun stuff there, but I do charge $500 per hour. I'm not really sure what that comment means, but it's $500 per hour.
Okay. What have you charged from the time you were retained until this point today?
I believe $4,500 was my bill. I think $2,000 more after that for updates.
Okay. And if I understand what you told me at your prior deposition, almost all of the money you make is providing this type of service in court litigation type services.
Yeah, there's not many of us with these kind of credentials, so it does keep people with my specific credentials quite busy.
And almost all of that's for the plaintiff. True?
No, my testimony list is mostly plaintiff. I am retained by defense firms quite often. In fact, I don't know if they've hired one of me on the other side. I don't think so, but I do defense work as well. So it's about 70 to 75% plaintiff. The rest is defense work.
Okay. But in terms of coming to testify, it's much higher for the plaintiff. True?
Yes, because on defense, they usually don't disclose us, right? I don't know if there's one that they haven't disclosed, and so we tend to not testify in defense.
So you said something that's super important for this case. You're here to try to analyze what Maya's diminished earning capacity, if any, was as a result of the actions at my client's hospital. Fair?
In part, yeah.
Well, meaning, don't you have an obligation before this jury to separate out how Maya was doing before she came to All Children's and compare it to how she did after?
Yeah.
Okay. And I think one of the words you used, so I'm gonna parrot it. You said, if I have it written down right, she was a runaway, was a freight train heading towards college.
Yes, sir.
Okay.
Yep.
Let me show. And you've spoken to a number of people. You've reviewed a number of medical records. Is that right?
That's correct.
Okay. Let me ask you about a couple of medical records. Let's pull up Joint Exhibit 1040-156. We'll put it on the screen for you.
Sure.
Mr. Trump. 1040-156. And you can expand the top. This is January 13th, 2016. I'll represent to you, this is from Dr. Hanna. Was he one of the people you spoke with?
I don't believe so.
Were you provided these records?
I believe so.
Okay. So you would have seen when you reviewed these records, for example, that Maya had pain that was 10 out of 10.
Objection, not reading. You can-
Cross-examination, Your Honor.
Overruled. He can proceed.
Okay. You see in this record that at the time Maya presented about 10 months before she came to my client's hospital, she was in 10 out of 10 pain, correct?
That's correct.
Okay. You know by history that this would have been less than 2 months after she underwent a coma in Mexico. True?
True.
And I really don't mean this to be sarcastic or make light of this situation. This is obviously very serious. She's in this position. She's not a freight train heading towards college.
When I talked to Dr. Kirkpatrick, the doctor that got all the CRPS going, I did ask him if this was managed early on, as it was, and there was no interruption at the hospital. Would she be in a much better position now, minus a PTSD? He said absolutely, and I even indicated to the doctor that when we have kids that have disabilities early on in age, they learn to adapt over time, and they have no choice but to go to college because they cannot work a physical job, and then they excel that way as long as they're managed. So I was very clear because I know this question is probably in everybody's mind. You know, what would have been like just the CRPS, and that's why I wanted to clarify that with Brewerton and Dr. Kirkpatrick.
Okay, Kirkpatrick hadn't seen her since 2015, September. True?
He's seen her after that.
Objection.
That's not true.
That's getting into court's ruling.
The last time,
Okay.
So going back to my question, based on the document I showed you in January 13th, 2016, you would agree with me at that point, Maya is not in a condition to be, quote, as you said, a freight train heading towards college in this condition. True?
Well, can we leave the record up,
Please. Clay, it's, you got it. Above it, it says the pain has been gradually worsening and described as severe, correct?
Yes. Yep.
Okay. And I'm just trying to establish with you at this date, you're not telling this jury that Maya Kowalski in this condition, hypersensitive, 10 out of 10 pain, wheelchair bound for now almost a year, 2 months post ketamine coma, is a quote freight train heading towards college, are you?
Absolutely, for reasons already stated. Because this is a treatable condition, certain protocols needed to be in place on an acute basis. It's very clear that this type of condition needs to be handled in the very beginning and without disruption. And there was a disruption. Now, again, as stated, persons that are injured when they're little, they learn to adapt, they get better, they cope. We know that this is going to have flare-ups in the future. And that's why, again, because of this question, because of this note, I wanted to clarify from the experts that I talked to that if it was handled appropriately, she was able to adapt and move on with her life with maintenance. Absolutely.
Okay, in fairness, you're not an expert on RSD in the treatment for it, correct?
I've had a lot of RSD. Well, RSD is the old term. CRPS is a new term. But I've had a lot of CRPS cases. Absolutely.
You're not a doctor.
No, not a doctor.
You're relying on Dr. Kirkpatrick for what he believes is the necessary care on CRPS when you're talking about what should have been given and what was interrupted. Is that true?
Dr. Henschke, Kirkpatrick, Brewerton, Chopra, all these doctors. Yes, sir.
Okay.
There's a convergent validation from all these doctors, all arriving to one single opinion. Yes.
Let me show you document. Well, let me ask you this. What was it that she wasn't getting at All Children's? Was it ketamine? Are you saying that there was an interruption of ketamine? Or do you know?
Well, that does call for a medical opinion. I tell you, she was also getting a lot of other things at that hospitalization too, if you want to ask that question.
Well, what I'm trying to get
There's
from
a lot
you
of things she got there that she shouldn't have got. Yes, sir.
No, you made a very specific statement to this jury that her CRPS therapy was interrupted, and that if it had only continued, she would have been better than she was, right? Do you remember telling the jury this?
Yeah, and that's based, again, on my conversations with the doctors in this case.
Okay,
Yeah.
so let me ask you about 5 months later, Joint Exhibit 104067. Again, this is a record from Dr. Hanna. It sounds like you reviewed this. This is May 13th, 2016. So we're now 4 months into ketamine treatments, and I'll represent to you. This is after she had 37 infusions. She a freight train heading towards college, 10 out of 10 pain.
Again, based on my conversations with the doctors, it's very clear that she had uninterrupted care and didn't take this big diversion of this captivity, if you will, at the hospital where she suffered all that abuse there. That is the opinion from the doctors that she would have been just fine in college, just fine at work.
Mm-hmm. And so you notice on the weight, she hasn't put on any weight. She's at 60 pounds. She was 60 pounds at the first appointment with Dr. Hanna 4 months earlier. Is that a positive sign?
Well, I mean, is it age and height appropriate at 60 pounds? I mean, that does call for a medical opinion. I see your point, but I don't know what her height and age was at that time.
Okay, well, let me turn to the next page of this 104068.
Obviously, if somebody's underweight, it's not good.
Okay.
I mean, stipulate that.
It's not just ketamine that comes with these treatments. You're aware in reviewing these records that there's a number of other drugs, including, if you look on the vials, Versed, Zofran, which is for nausea, magnesium sulfate for constipation, Benadryl to control against allergic reactions. That's all part of her treatment, right, that she was
Yeah.
getting? Okay. Let me ask you about another note. Let's fast forward a couple months to 1040-0040. She's still 60 pounds. You see that?
I do. Yep.
This treatment's working? Is that what you think?
Well, you're asking me if the treatment is working. It does call for a medical opinion.
Okay. Well, let's fast forward to the records just before she went to All Children's and see if you still see her as a freight train heading towards college. Let's pull up 1040-20. This is now 2 days before she went to All Children's on October 5th. The patient stated that her weekend was rough. She didn't sleep due to pain and had a great deal of nausea and vomiting. Is this a good sign?
I mean, if you're saying she's not, if you're making, you seem like you're formulating an opinion that she was not on a good trajectory. I'm saying that she was. There's no expert on your side that's refuting what I'm saying. I talked to the doctors. They were trying to treat her with this. We know that in working with pediatric children, the earliest you get to them is, and they can adjust to their disability long before college and get them on the right track. That is the point. So yes, I still stand by that she had everything going for her. She didn't have learning disabilities. She loved school. She had all this stuff. Despite all these things that she was dealing with, she was still progressing.
She wasn't in school. In October, she wasn't in school.
I'm aware, sir, but she's been through school from a young age all the way through.
Right, but from the time of her disability on July 3rd, 2015, into now this point where we're what, 17 months later, she's been out of school the whole time and in a wheelchair, right?
And look at her now. Look what
Objection is misstating facts.
Overall,
look
Not school.
at what she overcame. She missed school. She's been through it all, and now she's trying to get through college. 2 years of college as a junior in high school. So,
you will get-
again,
sorry.
the freight train analogy is alive and well.
You will get no argument from me, sir, that once she got off of these dangerous, unnecessary medications, with perseverance becoming a freight train heading towards college after the hospital, that's when she started doing this.
Well, that's your conclusion. You're making a medical conclusion, dangerous and unnecessary medications. I don't know if her expert doctors would say that or treat to that, but that does call for medical conclusion. Again, my analysis of this based on 4 or 5 experts in this case all have a convergent validation, meaning all opinions are converging into one opinion, and that is uninterrupted. She was on a really, really good trajectory. I don't think anybody can dispute that.
Well, let me ask you about 1040-0233. 2 days before she goes to All Children's, is this a good trajectory? She's non-functioning.
You indicating a measure of function for people with pain. She stays in bed all day, feels hopeless and helpless about life, and yet what has she proven? She's overcome so much.
Okay.
Absolutely.
Let's-
Even more so. I mean, you're almost bolstering my opinion because you're pointing out all these things that knocked her down, and she kept getting up. She keeps getting up, and she keeps fighting through all of this. So again, her power to go to do whatever she wanted was limitless, and nothing was getting her down at all.
The reason why I'm bringing this up to you, Mr. Tremp, is because your testimony from this jury was that this course of treatment from September, when Dr. Kirkpatrick started dosing her with ketamine, among other drugs, followed by a coma, followed by 2 boosters in Mexico, followed by 60 extremely high doses of ketamine given by Dr. Hanna, was the right treatment. And if only that continued for a couple more months.
Objection, counsel's testifying.
Cross-examination.
let him finish the question, and I'm going to overrule it.
And then if only that continued for another month or 2 and wasn't interrupted, she would have done this. Is that what you're saying? You can answer.
No, you can answer.
Yeah. Well, you said coma. It wasn't medically induced, medically supervised coma. It wasn't just a coma. Again, she did progress after that. She did better after that. And then we just won't know because she was, again, separated from her family for 97 days.
Well, we'll talk about that in a moment. After she got out of All Children's Hospital in January, you talked about her perseverance, her drive, all of those things. Those are
To this day, yeah,
amazing qualities. Nobody's disputing it. So
to this day.
that, her recovery, where she was able to go back to school by August with only warm water therapy, physical therapy, perseverance, and time. That's how she got to that recovery, true?
You're asking me how she got to that recovery. Again, that does ask for medical opinion. What I know about that is CRPS comes and it goes. It flares. It comes out of nowhere. It's why it's so anxiety ridden, because you just don't know when your next episode is going to be. So yeah, it's a good thing that she was able to get back to school. But how are we doing emotionally? What's left out of that question is the emotional component. He's asking about the physical act of being able to go to school. That's one thing. Okay, we can all show up to school. What's the emotional component of all of that? That's the other part of this.
She, well, you read the deposition of Mr. Kowalski, did you not?
I did.
And you saw that he testified in November 6, 2019, that he saw no evident signs of CRPS, correct?
And that's part of the disease.
Now, at that point, she's a freight train heading towards college. She's number one in her class, right?
Absolutely.
And she was able to resume figure skating for a while.
She's no longer doing that or piano, and she's no longer speaking Polish.
Okay. As of 2022, she was figure skating, playing the piano. True?
Fair. Yep.
And she's driving.
Yes, she's driving now.
She has a boyfriend.
Yes.
She had a job.
Well, I'll let her speak to that.
Yeah, I don't.
I'm not going there. She can answer that.
She had a job at Cracker Barrel.
Yeah.
She did you ever get her school records?
I don't recall.
You don't know what her school records say?
I'd have to look. Well, I got a lot of records. I mean, not much to really see. She's doing pretty well.
Yeah, I mean, I guess not to belabor it, she was, may still be, but at least for a while, she was number one in her class.
I believe she's number 2 now.
Okay. She was president of the Junior Honor Society after she got out of All Children's, true?
Was. Yep.
She was a member of several clubs.
Used to be. Yeah.
You, in order to prepare your vocational report, you had to interview Maya and Mr. Kowalski, right?
Yeah, several times. Yes.
Okay. You noted that Maya developed CRPS on July 4th, which gradually worsened, necessitating significant and prolonged medical care from multiple providers. True?
That's true.
You noted in your report that Maya had taken the SAT.
Yes.
You noted, at least at the time of your report, she had already gone to Stetson College in DeLand and participated in the science program.
That's true.
You noted in your report, when you asked her about her career thoughts, she was thinking about becoming either an orthodontist, a private investigator, or maybe going into psychology. Is that right?
That's what she said then. Yeah. Now she doesn't know what she wants to do.
I'm still thinking about what I want to do.
No comment.
Yeah. You interviewed Maya. This is as of February 10th, 2022. Did she tell you that she started her days at 4:30 in the morning and working out?
Yes.
And she was going to school?
Yep.
She would come home and help with chores?
Yep.
You saw where Maya had said in her deposition that she's physically doing better now than before she went to All Children's.
Yes.
Let me ask you a couple of your opinions on, well, let me ask you this. Were you aware of someone applying for Social Security disability benefits for Maya before she went to All Children's?
I don't recall.
You mentioned work as therapeutic.
Yeah, very. Yeah, absolutely. I hope she works.
Were you here earlier when Maya testified?
I was.
Okay. And you saw that she is going to seek out therapy, hopefully when this trial ends.
Well, I found that interesting because she wants to get better. She wants to see doctors and trust them again. And when I was listening to that, I'm going, when I've talked to her and her dad, the distrust is the big problem. And that's why I'm so guarded about her future, is because she's smart. She knows she needs help. But can she get out the door and go get it? And that's the problem. Is it just going to keep re-victimizing her, secondary to the trust issue?
Does you do concede, do you not, Mr. Tremp, that at least looking through her prior records, there were prior diagnoses of anxiety and depression prior to all children? It's true.
It's fair, yeah.
Okay. Did you read the report of Dr. Jim Lewis in terms of what he thought in terms of pre-existing anxiety, depression, and potential trauma?
Refresh me.
Oh, do you want to see it?
Sure.
Or do you want me to tell you what it says?
Whatever you want.
Maya had extensive clinical interview evidence of DSM-5 adjustment disorder with mixed anxiety, depressed mood, moderate to severe.
And this was by which doctor?
A neuropsychologist,
Employed by who?
not employed by my hospital.
Okay, and what date was that?
That was on October 20th, 2016.
It's fair.
Okay. One moment, please. Appreciate your time. I don't have any other questions at this time.
You bet.
Thank you.
Sure.
Just one second. Did it come to your attention, based on the medical records, that at the time of Dr. Lewis's interview of her, that Maya was heavily medicated and in the midst of her first relapse?
That's my understanding.
Do people generally perform well when they strike it? You were also asked about the effort she made 2-3 years ago. What is the problem with Maya not even completing a college application in her senior year?
Yeah, when I knew that coming in here today, I already talked to her about that, and it's very alarming. She's going into her senior year. I mean, kids started at sophomore year, junior year, they're starting to visit, and it just provides all the validation I need as to where she's at. I mean, she should be in 10 different colleges right now, at her pick, at her choice. She's not even applying to them, which is scary, and it's very concerning.
And in fact, she took the SAT once as a freshman in high school and has never taken it again. Come to your attention?
Yeah, I mean, she's avoiding. It's just classic, unfortunately.
And have you had the opportunity to see videos of Maya's progress over the course of the spring of 2016 and the summer of 2016, as the jury has?
Yeah.
Can we please bring up Joint Exhibit 1024-0028. That is Dr. Kreisman note dated May 11th, 2016. You were asked about a visit to Dr. Hanna, I believe, in early May of 2016, about 4 days before this. I'd like you then, I don't know if you recall this record or not, but if we could scroll down and let the witness take a look here.
What page is this?
Well, I'd like him to look at page 29 of 31, which is actually 0029, and more importantly, 0030. And I'll direct your attention to the physical examination.
I remember reading this.
And to come to your attention that Dr. Kreisman is a Johns Hopkins All Children's Hospital
Yeah.
physician, a pulmonologist to be exact, right? And so here, 5 days after seeing Dr. Hanna and complaining 10 out of 10, how is she doing according to this physical examination by a Johns Hopkins doctor?
Well, she's much better. Yeah, I mean, it says it all. I mean, I can read it into the record for my answer, but he says it's a totally different kid than what was previously seen. So,
In the matter of 4 or 5 days,
yeah, again, it speaks to the absolute importance of treating this early on and to see what you can do. And so, again, I think when I was questioned a little bit earlier, it's just, again, underscores the opinion that she was a freight train. She still is a freight train, but she's got a lot to get over now. You know, there's a lot more in front of the train tracks now than there was before.
all right.
She's a completely different child from when last examined. Yep. No pain, smiling, interactive.
Can you also look in the page before and note that Dr. Kreisman went over the various medications that Maya had over the past few years, not at one time. And then down below, see whether Dr. Kreisman had any problem with the medications Maya had been on or tried over the course of the preceding 2 years, excuse me.
Sorry, objection is outside the scope and also foundation.
Overall.
You're asking about the efficacy of the medications? Is that what you're asking?
Right. Does he doesn't put up, he doesn't question the use of any of these, does he, in his report?
Yeah, no, and again, it speaks to care. If a young child with a disability needs medications, they need medications. Again, it's to make them better, not worse.
And at the top there, does it appear that Dr. Kreisman, a Johns Hopkins all children's doctor, understood that Maya remains under treatment for reflex sympathetic dystrophy, also known, of course, as CRPS?
Yeah, it used to be RST, now it's CRPS, but yeah, it's there in black and white. Yep.
Interestingly, are many of these dangerous and, what was the term? Dangerous.
They were dangerous and unnecessary drugs was what I was told earlier today in my testimony.
Horrible drugs like vitamin A and vitamin C.
Yeah.
And Tussinex.
Yep.
And magnesium oxide.
Yep. Flonase for asthma.
Singular. Aren't most of these simply over-the-counter medications?
Claritin, a lot of supplements. Yep. Asthma-related.
Mm-hmm.
Yep.
Now, your testimony is grounded not only in Dr. Kirkpatrick, but it's grounded in Dr. Henschke. Is that right?
I mean, Henschke, Chopra,
Brewerton.
Rebecca Johnson, Brewerton, all the other treating and expert physicians. Absolutely, I talked to them all. And it's important when we're making life-altering decisions about somebody that I do talk to people, right? I could be impulsive as well.
Non-responsiveness.
Sorry, I need to make a correction. I just looked at the note, and actually the visit to Dr. Hanna was on May 13th, 2016, where she complained of pain of 10 out of 10. And so how many days difference then? Did Dr. Kreisman see her and she appeared to be doing just fine? In fact, better than he'd ever seen her. And then going into Dr. Hanna and having severe pain.
I don't have it in front of me. You have a date range for me?
It's 2 days,
2 days.
3 days.
So treatment works.
And so is this the essence of CRPS?
100% across the board. Absolutely. They flare up and you get treated and you get back after it.
And finally, just to eliminate any confusion here, the baseline you were testifying to from which you judged the diminished earning capacity, that included CRPS, but controlled CRPS, did it not?
Yeah. So again, I really wanted to explore and make sure from the doctors, would she have been interrupted much at all but for the captivity for 97 days? And it was always, if she was treated and there was no disruption, she would have been well on her way with limited impediments.
Let me rephrase that. I'll rephrase.
Approach.
Okay, I've been handed a note from the jury that they want a break, so we're going to take a break. Members of the jury, do not discuss this case amongst yourselves, do not do any investigation, and receive no information. Let's try to keep it to a 10-minute break.
All right.
Katie. The jury is out of our presence. Any issues we need to address before, hey, sir, hold on a second, don't go. Any issues we need to address before we go on a break?
No, Your Honor.
No, other than whoever knows my position on the curative instruction, but otherwise no.
And sir, you're in the middle of your testimony, so do not discuss your testimony with anybody.
Fair enough. Just leave it.
You can use the restroom.
Judge, may I have one exception to that with counsel's blessing? I wanted to instruct him to ensure that we never
Both
had.
of you can be together when that happens.
Perfect.
Okay? 10 minutes, everybody. Fantastic, thank you.
Yeah, they're stapled together, but they're back to back.
I think your clerk has copies as well from us.
Yep, and what I'll do is, so I take that back to Sarah.
Thanks, both of them. Okay. And where are we at this point? Are we ready to bring the jury back? Are there any issues we need to discuss?
We're ready, and I'm just gonna stay away from it. I'm not gonna reemphasize anything. I've got two more questions, and that's it.
Thank you, we're ready to proceed, Your Honor.
Okay, let's bring in the jury.
Background training, experience, and background. Okay.
Ready. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? Correct. Mr. Anderson, you may continue.
Trump, your numbers, were they based on Dr. Kirkpatrick's August of this year reevaluation of Mike Kowalski?
In part.
And in terms of determining whether this freight train is going to stay on track, can you tell the jury what problems there might be, given Maya's expressed fear of hospitals and even just certain medical providers?
You know, when I look at this and answer that question, I keep looking for alternative paths to guide her for her future. And I keep running into roadblocks along with each path, each creative path that I take, because of the synergistic relationship between the pain issue from CRPS and the PTSD and how they just chase each other around and around. And then you take the PTSD alone from all of the different things when she's in public, when she's at work, people look like people from Johns Hopkins. People have the same jewelry. They wear the same color clothes. Again, for the third or fourth time today, just the ticking clock. So all of those types of things, as well as one of the most, I don't know how to characterize it objectively, but I'll just say it plainly. The issue from Dr. Brewerton, and this is from my clinical experience as well, about the reconfiguration of her neurobiological responses with a developing brain. So she's not the same person today as she would have been without the trauma.
Is that why your opinion is guarded?
Very guarded. Yeah, very. Yeah.
Nothing further, Your Honor.
Nothing at this time, Your Honor.
Members of the jury, do any of you have any questions for this witness? Okay, go ahead and write them out. of the jury, let me go ahead and ask the questions. As a vocational coach, will you continue to work with Maya, or will Maya continue to work with a vocational rehab coach throughout her life?
That's a great question, and really, a coach counselor, really, it is counseling, vocational rehabilitation counseling. I absolutely recommend for her to have ongoing counseling now for her whole work life expectancy, and I believe that will be a lot of the counseling is addressed in the life care plan, which you're going to hear about after me.
Next question. The more Maya goes off track as time goes by, will it become harder to get her back on track?
Boy, you guys got good questions. You really do. 100%. I mean, when we go back to Dr. Kirkpatrick, the Maya that was, we will never meet. We'll never know Maya. The Maya we have now after the trauma is a different Maya than how she was born. She's altered. Absolutely different. So the longer she deviates, she'll never catch up to the gap, right? If she was on this trajectory, she's always going to be kind of behind. We're now looking at her in her senior year with all that academic prowess, not even one single college application. That's alarming. So yes, absolutely. The compounding effect. And I did talk to Dr. Kirkpatrick quite a bit about that. In her 30s, life issues, marriage, kids. If she chooses to have kids, I don't know. Because, she's going to fear about them being taken away and going to a hospital while pregnant. I mean, how's she going to trust anybody? So yeah, absolutely. It's a tough road for her, and that's why it is so guarded.
Any further questions?
No, Your Honor.
No, thank you, Your Honor.
Okay. May this witness be excused?
Please.
Thank you, Your Honor.
Yes, sir.
Okay. Thank you, sir. Thank you. And Mr. Anderson, your next witness, please.
Dr. Bifulco. Dr. Bifulco. Last one for the day.
Right this way, sir. You stand here, face the clerk, and raise your right hand.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
I'll have a seat on the witness stand.
Well, it's 3:20 on Friday, so I'm going to be as fast as I can.
Yes, sir.
I'll get this out. Please state your name for the record.
Santo Stephen Bifulco.
And are you a medical doctor?
Yes, sir.
And where is your practice?
Tampa, Florida.
And what type of doctor are you?
Well, I'm a medical doctor. I'm a specialist in an area of medicine called physical medicine and rehabilitation. Physical medicine and rehabilitation is also known as physiatry, not podiatry, not psychiatry, but physiatry. Physiatry is made up of 4 areas of medicine: orthopedic medicine, not surgery, neurology, physical therapy, and pain management. In addition to having practiced in that specialty for 33 years now, I am a board-certified life care planner, physician life care planner, and I've been doing that for more than a decade.
All right. Can you tell the jury a little bit about your background, training, and experience? I've gotten a few things to them, but start with undergrad and work your way over.
So I know it's late, and I'll give you the short version. After high school, which is 12th grade, I went and trained for an additional 12 years. We call that 24th grade. Those 12 years began. So I started this journey in medicine 44 years ago when I finished high school, when I came to Tampa, and I started my undergraduate studies. So the first 4 years after high school were undergraduate or pre-medical studies. I went to college in Tampa, got a degree in biology. I applied to a number of medical schools. I was accepted, but I chose to stay in Tampa at the University of South Florida College of Medicine. So the next 4 years of that 12, I was in medical school, University of South Florida College of Medicine. 1982 to 1986, I finished medical school and I was given a doctorate degree, but doctors don't have enough training or education or knowledge to practice medicine. We are required to do at least 1 year of additional training. I went to New York, lived at a 1,300-bed level 1 trauma center where I did a 4-year residency. First year was internship in internal medicine and cardiac care and emergency medicine. And then the next 3 years of that 12 years, the final 3 years of the 12, I did my residency in physical medicine and rehabilitation, where I worked along those doctors that later hold themselves out as orthopedic surgeons, later hold themselves out as physical therapists, later hold themselves out as neurosurgeons and neurologists. So after completing all of that training in 1990, which was 33 years ago, I relocated back to Tampa Bay, and I've been in private practice in the Tampa Bay area since then.
Okay. And in addition, like you said, you're a life care planner. Why don't you explain to the jury a little bit about what that is?
So a life care planner is someone who has the requisite training and experience to write a life care plan. What is a life care plan? Well, a life care plan is a dynamic document that's based on standards of practice and a methodology that's been around for a long time, since the mid-1970s. And it really started as a case management tool for individuals that have chronic, catastrophic, or permanent injuries. And it was a way to educate all members of the treatment team, as well as family members and an injured person, as to what the trajectory of care should be over someone's life. So a life care plan answers 3 questions. What does someone have? What does someone need? And what will it cost? So it's essentially a care plan, which every doctor, when you go to a doctor, they always do a care plan. The difference is a life care plan adds a couple of factors. It adds the care over someone's entire life, not just between now and when I'm going to see you in the office again, and it adds cost. And so a life care planner is someone like myself that's gone through the necessary training, has the experience and the knowledge, and I'm board certified. I've been certified twice as a life care planner. So that is a national certification. I see patients from all over the country and even outside the country. So that's what a life care planner is.
Got it. All right. We're talking here about PTSD and CRPS. 2 questions. The first one is, have you had sufficient clinical experience with a CRPS to give the jury some idea of how, second question, as a life care planner, this presents difficulties, opportunities, or affects it?
I have treated individuals with complex regional pain syndrome for the last 33 years in private practice, as well as post-traumatic stress disorder.
Okay.
I see it frequently in my practice.
How often, just out of curiosity, do you see CRPS plus PTSD? Kind of sounds like an unusual.
It's not that common. And when it is present, the problem is it's not like 1 + 1 = 2. It's 1 + 1 = 10 or 11, because those 2 things potentiate each other. But it's a great question. We see complex regional pain syndrome often because I'm a trauma physician. So I see these kind of injuries, and I see post-traumatic stress disorder often. But you're right, you don't see them together all the time.
All right. And where are you licensed to practice medicine?
I have an active and clear license in Florida, of course, California, and New York.
And are you certified in any
Yes.
areas? In what areas?
So I have specialty certification, of course, and I'm board certified in life care planning. I have specialty certification in disability evaluation. I have specialty certification in interventional pain management, which means that I could put a needle in most areas of the body in order to reduce pain.
It seems to be more and more the case. Do you do those, what do they call, the denervation surgeries at all? You know, where the nerve burns? Whatever. What is that called?
Well, so you brought.
I had one. I was just curious.
Well, radiofrequency neurotomy or radiofrequency ablation.
Okay.
So physical medicine rehabilitation is a non-surgical specialty in that I do not do surgery with a scalpel, but it's a surgical specialty in that the definition of surgery is anytime you pierce the body cavity, that's surgery. And I pierce the body cavity a lot because we do all kinds of injections. So by virtue of the injections, those are all surgical codes, but I'm not a surgeon in the way that a neurosurgeon or orthopedic surgeon holds a scalpel.
Got it. All right. So what was your job here? What was your, and before I ask that, were your results provided to our economist here, Christy?
Absolutely. We communicated, I provided my report, and as you heard this morning, I've been here all day, she based her numbers on my report.
All right, and to the best of your knowledge, and have you worked with Mr. Trent before as well?
I have.
All right. And were his numbers also provided along with yours to Christy Kirby?
Yes.
And do they form the basis of her numbers that she gave to the jury here?
Yes.
All right, so now tell the jury what your assignment was with Maya Kowalski, and then I want to get into what you did so that you can inform them here today of your opinions.
Yeah, my assignment was quite simply to independently evaluate Maya Kowalski, to be available for expert testimony if I was called. I was retained in this case more than 3.5 years ago, to independently evaluate her and to be able to formulate the necessary opinions to outline the care, treatment, and cost of her care over her lifetime.
All right, and so what did you do towards figuring that out?
Well, I have approximately 75 hours into this case, so I did a lot. First and foremost, when I'm retained, the first thing I do is I make sure I don't have a conflict. I am retained by both defense and plaintiff counsel. Make sure I don't have a conflict, and I did not. Then I request.
How did we get together? Just so.
Actually, I think that I testified, and you were opposite. You cross-examined me. You were on the defense. You were on the opposite side, and I testified.
Go
Yes.
ahead, sorry.
So, the first thing I do is I request all documents in the attorney's file that hires me. And I call that factual information, because the methodology, the three basic steps of the methodology that I follow are facts, opinions, and conclusions. So before I could arrive at sound opinions, or final conclusions, I have to have enough factual information to be able to arrive at sound opinions. I never know or never assume that I have every piece of factual information. In this particular case, Maya was very young, but I see individuals across the entire spectrum. So I never assume that I have every record in the universe, but I request every document. That means thousands of pages of medical records, which I reviewed. Lots and lots, maybe 25 depositions which I reviewed. Interrogatories, medical bills, basically every piece of factual information which counsel can disclose to me, I ask for and I review. That's the first thing I did. Then I asked to evaluate Maya Kowalski. I wanted to have an opportunity to see her in my office, but that was not possible. So I had 4 telemedicine visits with Maya, her father, her brother, but I only evaluated Maya. But I wanted her family involved so I can get an accurate picture. In addition to those telemedicine visits, I spoke with her treating physicians on a number of occasions. I spoke with them, I communicated with them, I reviewed their records, I reviewed their updated records, their reports, I coordinated my opinions with Mr. Trent. So essentially, when I say factual information, it's all of that. And then I apply my training, my education, my experience, and my knowledge so that I could start to now move from facts to opinions. And those opinions are, does Maya have a permanent injury? Yes. That's the first criteria. I can't move to writing a life care plan unless she has a permanent condition. Then I have to ask myself, does Maya Kowalski have a permanent treatable condition? Because if she doesn't have a treatable condition, then a life care plan doesn't make any sense. So she met that criteria. So I start now to move on to opinions. If she has a permanent injury, and if she has a permanent treatable injury, I start to then formulate what are the categories of care. And I do that not just by relying on my own training and education, experience, and knowledge, but I reach out to, and I read all the medical records, and I specifically asked her doctors on multiple occasions, tell me what Maya Kowalski needs because of the trauma she sustained. So it's important to understand the care plan is not to treat her complex regional pain syndrome, which she had before the trauma. It's to treat the condition and the conditions that she now has as a result of being traumatized. And that's the...
Your Honor.
It's going to take a few minutes. Can you go back to the room? Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right.
Jury's out of our presence. Doctor, if I could have you step outside, please.
Yes, Your Honor.
Everyone, feel free to sit down. Okay, the doctor is outside of our presence. The jury is outside of our presence.
Yeah, the defense would like to make a motion to strike his testimony. I took his deposition. I asked him this question 3 times, starting on page 41. Quote, in terms of what Maya was going to need, irrespective of encountering Johns Hopkins All Children's Hospital in October 2016, you have not developed an opinion. True? Answer, that's correct. And just to make sure I wasn't missing something, I asked him the same question at page 46. And so whether Maya Kowalski was going to need attendant care, regardless of the treatment at All Children's, you're not making that determination. This is only based on what her needs are now. True? And his answer was, so I think you've asked me this question a few times. I have no opinion. I'm not going to speculate about what Maya would have needed but for the subject tort. And there was no discussion with her treating or consulting physicians regarding what she would have needed had this not occurred. Same question with regard to her psychological needs. Are you making a determination of what she needed but for the treatment at All Children's, or is this, again, just what she needs without any reference to that discussion? Answer, there's no determination, no speculation on my part is occurring about what she might have needed had it not been for the events in 2016 at All Children's Hospital. I couldn't have confirmed this more with this witness. I was never notified that he was going to show up at court and say, all these treatments in my life care plan are a result of, mistreatment, whatever he wants to say at All Children's Hospital. It's a surprise opinion. I moved to completely exclude his testimony. I moved to strike his life care plan. If he's going to proceed at all, I would like the questions to be very clear that his opinions are only, this is what she needs now, but I'm not alleging it's due to anyone's negligence. This is completely unfair.
Your Honor, those opinions and those questions and answers strike me as the inverse of the positions the defense counsel is taking. Those sound to be responses that Dr. Bifoco has not formed opinions as to speculate as to what she would have needed prior to All Children's. He's confirming in those answers that his opinions account for the trauma at All Children's. That's how I understand those answers and those exchanges.
Not only that, we provided them with an opinion, with a report in this case, which stated, and a disclosure, which stated that he was going to testify as to all of this.
Well, let me see the report that was.
When was that dated? I got a report last night. There's a report dated August 29th, 2023 that I was forwarded some additional materials last night around 7, if that's what it was included in. I moved to strike.
We sent it to you.
Provided many times before that.
Well, it's dated August 29th, 2023.
Let's go with something that was timely produced under the court's order, not something that was given to them a couple minutes ago.
Sure. And we did have, there was an order from this court that we could provide supplemental reports of our life care plan or voc rehab. And so there's a specific order on this.
So is this?
And this is the one that would have
Is
been.
this timely under that order?
I need to go back and look at
The order, though, was because their numbers were going to change. Sorry.
I just, first off, is the report that's in Mr. Anderson's hand, is it timely under the court's order?
I'm going to look at the date of the order.
Okay.
report, maybe, let me see that.
And while they're looking, I would note for the record that his errata sheet is empty, so he didn't attempt to change his opinion either.
Well, I mean, if it was in his original report, then it's a question of impeachment. If it's not in his original, or if it's not in a timely disclosed report, then we might have a different issue.
Can I make a comment?
Sure.
The reason they were allowed to give new reports because they said the numbers would have changed given the fact that the trial had been delayed, not because they have new opinions or expanded opinions. And so the court allowed them to do, for the life care planner and the economist, new reports because of the delay of the trial and new numbers.
I need to find our disclosure. I'm confident, because that was the entire purpose of the witness, Your Honor, that you provide disclosure.
Your Honor, I've located our expert disclosure from 2021. I hesitate to bring it up yet because I don't have the DIN for it, but I can tell you the date of it.
Tell me the dates.
October 15th, 2021.
Well, how about his actual report? If you're talking about the plaintiff's third amended expert witness disclosure, that's DIN 1912.
The only report that I ever received from him is the life care plan projections that are replete with notions in here that what is required for her is a result of CRPS, which was entirely consistent with his testimony. For example, I mean, this is the one that was even provided to me, that was provided last night, but it was dated August 15, 2023. Page 6 of his report is all about what he needs because of CRPS. None of this is about exacerbation. I received this last night. My point to the court is,
I understand your point.
I get it. I'm frustrated. I apologize.
It seems to me, Judge, that this is going to take quite a while. It would have been nice if we knew this was coming up, if counsel had some idea that this would be a major issue, that we weren't discussing it at 4:45. 3:45, excuse me. We may need to go home and look through everything we've got and find out what's up. But I am confident, because he's a life care planner about Maya Kowalski's condition, the only reason we would have him would be to comment on why she has these based on what happened to her at Johns Hopkins. There's no other rational conclusion in this. And so I question whether this is truly surprise and whether this is truly some kind of prejudice here, or whether we're the victim of a gotcha unprepared. Because if I had known about this, I would have gone through the entire history of the experts. This case went to trial, not to trial, but this case went 4 days before trial a year and a half ago. And I know at that point we had made full and complete disclosures. I didn't hear anything at that time, and I didn't hear anything in the pretrial here. Now we are in this situation, and I'm certainly not going to give up on the witness's testimony. I suggest that I be allowed to complete the deposition, and then if we can't prove to the court's satisfaction and counsel's that yes, he was informed that my life care plan expert was in fact going to testify about a life care plan as a result of a tort, then we can move from there.
Respectfully, Mr. Whitney, who's a fantastic attorney, was at this deposition, and you can see the reason why I asked Dr. Bifocal this 3 times, to the point where the 3rd time, I'm like, I'm sorry to keep harassing you about this. I want to make super sure you're really not going to come to court and say, this is because of what your hospital did. You're just saying, this is what she needs. He couldn't have been any more clear. If they wanted to make a change to this, they could have done an errata sheet. They could have said, hey, Mr. Shapiro, he's reconsidered. It wasn't my obligation to tell them that their life care planner conceded to me at their deposition, when respectfully Mr. Whitney listened to this and did not cross him to try to rehabilitate him on the subject.
Again, I read the question, you exchange it differently. The report, the initial report is from February 5th, 2022. Our legal assistant is printing it, but we can display it for the court. Go ahead, next page. Can you enlarge it perhaps?
Just, and for the record, while you're reading this, I deposed him after this to ask him about these opinions, and that's when he conceded. So this is not a subsequent disclosure trying to account for his testimony. I had this report, I had his life care plan.
My thought process, Mr. Shapiro, is I first want to know is if some semblance of an opinion was disclosed in the expert report about what he testified to here. And so just go to the next page. Are you going to be able to show me anything close to what we need to see?
Sure. Go to the first page again. Second page, my fault. Okay. The purpose of my evaluation, bottom here, the purpose of my evaluation was to assess Maya's current issues related to the incident that began on October 7, 2016, when she was separated from her family and retained at Johns Hopkins Children's Hospital for 97 days. He's been instructed not to get into the fulsome 97 days. But go ahead. Let's go down. Keep going. Maya has suffered a traumatic event that will have a lifelong impact. He's describing there. His opinions again. Life care, planning, certainly related to the traumatic event that began on October 7th, 2016. I mean, it's just inherent in this report that these are his opinions.
Well, that's what his report's about.
Copy if the court would prefer.
So, on page 5 of this document, it does say the life care plan in this update outlines the minimum care Maya's needs within a reasonable degree of medical and life care planning certainty related to the traumatic event that began on October 7th, 2016, which would exclude the onset of CRPS originally. I agree with Mr. Shapiro that this deposition seems to be replete with opinions that might be at odds from this document that I'm looking at on the screen. The issue to me, though, is it a surprise? And if you had the written report, did you ask about, hey, your written report seems to be at odds to what you're saying?
Respectfully, the whole reason why this is so complicated and respectfully convoluted is because we have testimony in this case from people like Dr. Chopra and others who will say and have said CRPS is this lifetime permanent condition, right? That will never be cured and that Maya was going to need care for the rest of her life. So my plan, coming into Dr. Bifocal's deposition, was to try to get him to say how much ketamine, how much rehab, how much PT was she going to need as a result of her just having CRPS versus how much was she going to need as a result of whatever re-injury or whatever lapse in care that you were going to allege. But what Dr. Bifocal said unequivocally to me 3 times, and the reason I asked it 3 times because I was in a little bit of disbelief, but if he wants to say, Mr. Shapiro, I am not coming to trial to tell the trier of this fact that my life care plan is related to a trauma at All Children's. I'm just coming to say this is what she needs. I can't do any more than that. And that's why I asked him the question, not once as a gotcha, not twice, to the point where you can literally see in the transcript, I'm saying, I know you're sick of me asking this, but just to triple check. And this is exactly what the Binger rule is designed to prevent, is an expert, after his report, I get his opinions, he says, I am not going to testify to that. Mr. Shapiro, I promise you, under oath, my entire report is based only on what she generally needs and not based on what your client did. And now he's taking the stand at trial.
Well, what you just said, are those words in here, or is that your interpretation of those words?
Those are his exact words in the deposition. I would encourage your honor to read it again.
Can we point your honor to page 30 of the deposition?
Leave that back up, please.
Yes, sir. At page 30, beginning at line 4.
No.
And then
Mr. Shapiro?
you can see how it continues, but then I asked him, in order to take into account the damages that are solely owing to the incident at All Children's Hospital, you would have to determine what she would have needed had she never accounted for her visit. True? He says, that's not true, and I give him an example, and then I finally say, so are you going to come to trial and say, this is what she would have needed before, and now she needs much more after? He said 3 times to me, no.
Well, if the question is unfair surprise, when the witness at page 30,
I'm sorry. Please go ahead. I apologize. It's late.
I'm happy to, if there's anything else you want to say, I'm going to listen totally to what you have to say, then I would ask for the same courtesy of
Yes, Your Honor.
listening to me. So is there anything else you would like to say?
Only, just again for the record, the questions after he initially said that on page 30, I asked him 3 times to confirm at pages 41, at pages 46, and at pages 47, the exact question that's at issue. Again, this is only based on what her needs are now, not because of what she went to All Children's. Same questions with regard to her psychological needs. Are you making a determination of what she needed but for the treatment at All Children's? Or is this, again, just what she needs without any reference to that discussion? And his answer was, there is no determination. No speculation on my part is occurring about what she might have needed had it not been for the events in 2016 at All Children's. And so, again, I apologize for my demeanor, Your Honor, but it's very frustrating to me because now a witness is about to take the stand. I've had no opportunity to try to separate out what would she have needed before and what would she have needed after, because he conceded that's what he wasn't planning on doing. Thank you, sir.
The court has before it the defendant's motion to effectively strike the testimony of the expert, Dr. Santos Stephen Bifocal, on what the defense contends are undisclosed opinions, specifically the opinions relating to the type of damages that Ms. Kowalski sustained at the hands of the alleged conduct of Johns Hopkins All Children's Hospital, and not the just general, hey, she has CRPS, and the type of treatment she might need in the future. There has been testimony replete throughout this trial about the exacerbation or activation of a defect, latent defect is kind of the legal terms and what the jury instructions go to, about the conduct of Johns Hopkins All Children's Hospital has made and will permanently make Maya Kowalski's conditions worse. I understand where Mr. Shapiro is coming from because, and I will totally agree, that there seems to be several passages where Mr. Shapiro did specifically ask that, try to separate out, or are you going to try to separate out, please keep that up. Try to separate out what was the alleged conduct responsible for versus what she had just as a generalized condition. So the question is, was the defense surprised by Dr. Bifocal's testimony here? Now, the reason why I wanted to see the report, and this going back to the original report from, looks like February of 2022, on page 5, it specifically says, the life care plan in this update outlines the minimum care Maya's needs within a reasonable degree of medical and life care planning certainty related to the traumatic event that began on October 7th, 2016, which excludes the beginning of her CRPS. When we look at Dr. Bifocal's deposition on page 30, at lines 9 through 17, the life care plan takes into account the incident that occurred at All Children's Hospital, and that being the major contributing cause for the need for future care. That is the major contributing cause. And as I spoke with her treating and consulting physician, that is the focus. In other words, what does Maya need as an individual, as a human being, now that has occurred? So the question is this an unfair surprise? The court has to say no because we had a written report and Dr. Bifocal said that in his deposition. Can the defense impeach him based on his statements, multiple statements? Absolutely. I'm sure they will. But it's not an unfair surprise. The court is going to deny the defense motion because it's evident, based on both the report and earlier in the deposition, that the defense was on notice that he was testifying relating to damages caused by Johns Hopkins All Children's Hospital's conduct, alleged conduct. So that's the ruling. Let's move on.
What do you call Dr. Bifocal?
Let's go bring in the jury and bring in Dr. Bifocal. Is it bifocal or how do you say it?
Bifocal.
Bifocal. Okay, everyone, please be seated. Members of the jury, I just want to confirm that you were aware you did not discuss this case amongst yourselves, you did not do any investigation, and you did not receive any information about this case. Is that correct? And that no one approached you about this case. Is that correct? And have you seen any media coverage since we were last together? Okay. The court is overruling Mr. Shapiro's objection, and Mr. Anderson, you may proceed.
I hesitate to ask for you to read back the last question. You want me to just ask another one? It's right. I'll ask another one. All right. All right. Let me get to opinions here. I think we were talking about the basis of your opinions and the fact that you had read a number of depositions. Which of the physicians, well, I'll ask you, which of these physicians you relied upon in formulating your plan? Dr. Kirkpatrick?
Yes.
All right. Dr. Brewerton?
Yes, of course.
Dr. Henschke?
Yes.
Dr. Chopra?
Yes.
And Rebecca Johnson.
Yes.
All right. Now, after that after reviewing these matters, I want you to again refresh our recollection about what you were asking about in these. What do you call them? Telemedicine visits? Is that what they're known as?
Telemedicine encounter.
Yes. Tell the jury what you were looking for and what you found out in those.
I was gathering factual information as part of my analysis. Those 3 steps are facts, opinions, and conclusions. Before I could even move on to sound opinions and conclusions, I have to make sure I have all the factual information. And part of that is, as a physician, as a medical doctor, I have the capacity and the responsibility and the ability to evaluate Maya and to confirm that what the other medical providers have seen and done and heard is actually what's going on. So as a medical doctor, I did that. Now, I didn't have, unfortunately, the opportunity to examine her with my own hands. I did invite her to come to my office, but as you heard for weeks, she is cautious of physicians, and I understood that. And so we opted at this time to do a telemedicine visit. And I spent a lot of time with her on Zoom, face-to-face, interviewing her, asking her, confirming all of the things that her treating physicians told me, all the things that are in the medical records. I wanted to confirm them with my own eyes and ears. Is this true? Once I did that, and I was certain that I had enough factual information, then I moved to sound opinions, and I started to explain what those opinions were.
All right. If we could, let us go through your opinions. If you need to refer to your notes to begin with, I think this is at page 3 of your report, or you can direct me elsewhere.
So there are actually 2 parts to my report. There's a narrative report, which is just typed words, and then there's the care plan, the life care plan. Which would you like to look at?
Can we go through just very briefly the basic recommendations in your narrative
Yes.
and the support there? So we have
Yes.
some context for the life care plan.
I would refer you to the very last page. Well, the last page is a signature page, but that's page 7, where the first thing I say is, what is a life care plan? And I've told you that the lay definition is, it's a report, it's a dynamic report because it changes as things change, that answers 3 questions. What does Maya Kowalski have? What does she need medically, and what will it cost? But there's a stated definition, and that definition is, life care plan is a dynamic document based upon published standards of practice, comprehensive assessment, data analysis, and research.
Your Honor, I object to him just reading from his report.
Okay, I sustain that.
You can just summarize it very quickly.
Okay, so what does she have, what does she need, and what does it cost? And then I say, what are the goals of this care plan? And I state what the goals are. And then I move into my opinions and conclusions.
What were, I know you've said it in macro, what were the goals for this young lady?
There's 5 objectives. The reason you treat anyone with a permanent treatable condition are 5 things. Number 1, you want to reduce her pain and suffering, despite what happened to her. You want to increase her quality of life. That's the reason why we treat, despite what happened to her. You want to help Maya Kowalski reach her highest level of function and her highest rehabilitation potential. And perhaps the most important of the 5 is the reason you treat or implement this care plan is to help her avoid avoidable complications, things that will more likely than not occur if she's not treated.
So was the idea here, strike it, based on your clinical experience and your studies, is CRPS curable or is it a manageable disease?
It's not curable. It's a lifelong condition that is incurable. It's manageable.
So one of the purposes of the Life Care Plan to find the best opportunities to manage this, to maximize the patient, in this case, Maya Kowalski's abilities to function normally in life?
Yes.
All right. So then let's move, unless you'd like to add anything else as to the background of it that the jury should know, into your Life Care Plan and how you, just explain how you came to it and what it is.
Well, how I came to it was I considered everything you sent me,
Right.
everything I learned from my multiple telemedicine interviews, and everything I learned from reading all of the medical records and then speaking with and communicating with or treating physicians. That's how the Life Care Plan in this case was created. It came directly from her treating physicians by me asking Dr. Kirkpatrick, Dr. Brewerton, Dr. Wassenaar, tell me what Maya Kowalski needs within a reasonable degree of medical certainty. I'm not asking them to predict the future. That would be speculative. I'm asking them to tell me within a reasonable degree of medical certainty and probability, what does she need? What is the item? What is the frequency? And what is the duration? My job is then to do the research to determine what's the cost. The doctors generally don't give the cost. Now, Dr. Kirkpatrick's different. He's an expert in his field. He knows the cost. So he gave me the cost for certain things. And so the very last thing I would say is that last paragraph in my narrative is really the 500-foot view. It's the top level view of what we're about to talk about. And what I did was I separated her care plan based on everything I reviewed into categories of care. And then there's 6 categories of care, big categories. And then within those categories, there are a couple of items each. And that lays out the entire trajectory or roadmap to her recovery.
I'd like to pause for a moment, Your Honor. May Mr. Whitney write these down at the seat there rather than going through putting them up? The numbers.
That's fine, just be wary of sightlines. And if
Yes,
members
sir.
of the defense need to move to either over there or over there, that's fine.
Do you have something to write with?
Yes.
I'm ready. Okay. So, am I on the right page here to Trial Exhibit 2343009, beginning your Life Care Plan? And this is not in evidence at this point, Your Honor.
Mr. Anderson, you asking me a question?
Yes.
No, I would say you should be on 2343007,
I'm sorry.
page 7.
Okay. If you could then,
And it would be
go through, please, the opinion, and are these opinions to a reasonable medical probability?
Of course.
Right.
And starting with the paragraph, I think it's the second to the third.
Right.
The Life Care Plan includes 3 options. That's what I'll be reading from.
All right, and so what is the first option in the best case scenario?
So the Life Care Plan includes 3 options for long-term needs. The first option is the best case scenario, and the total value of this scenario is $2,499,597, period. There are 2 options for the worst case scenario. One outlines the cost to privately hire caregivers, and the other option outlines the cost to hire caregivers through a home health agency. We call that private hire versus an agency, period. The total value of the Life Care Plan in the option where caregivers are privately hired is $6,660,597, period. In the option where caregivers are hired through a home health agency, the total value of the Life Care Plan is $8,063,077. The value of the Life Care Plan options have been calculated using simple math. The values have not been calculated to present value, as this requires the service of an economist, which you heard from earlier today. So that's the 500-foot view.
All right, and these were provided to the economists that the jury heard from earlier.
Absolutely.
Okay, so Now, I'd like you to explain to the jury, because they heard from Mr. Tremp earlier about the 100% loss, if you will, for Maya, and then the 50%. And could you explain how they interact with these amounts?
So
What's
what
the
Mr.
goal?
I'd be happy to. What Mr. Tremp was,
Objection outside the scope of his report.
I'm not sure I understand.
one question, Mr. Anderson.
I have one question.
Explain the inverse relationship between the two. All right.
What's the question?
Between the diminished earning capacity from 100 to 50%, 100%, versus the increase in cost of the life care plan. How do they work together? Don't, you know what?
They're two completely separate things.
Mr. Trump covered that, so. All right. The support for your plan there, I think we should go through a little bit of it so that we have a record here of exactly what you were provided and some basics. And I don't want to go through all of the actual numbers, but I do want to go through the services if we could. And now I'm on page 9, is that right? Can we?
Yes.
Okay, yay. So what is the first, under the projected evaluations, what is the first item in service?
So the first category, you have to understand, is projected evaluation. In this category, there are 4 items. Number 1, there's no cost for this, but it's an item. Rehabilitation and long-term needs assessment. That's what this is. So it's already been done. There's no cost. The second item is neuropsychological evaluation. This was provided by Dr. Brewerton. It's a one-time fee, one time in her life, not one time per year, just one time, and the cost is between $1,300 and $3,509. The third item is a physical therapy evaluation. This is one time per year for 10 years, and the basis for this, or the foundation for this, was Dr. Wassenaar. The last item in this category of projected evaluations is a dietitian evaluation. This is one time per year for 10 years of her life, and the basis or foundation for this was Dr. Wassenaar. So that concludes projected evaluations that Maya Kowalski needs.
I note you had a footnote under the first one, rehab and long-term needs assessment, about this being a dynamic document. And I also note this appears to be set out in 10-year increments. Are you suggesting that all of this starts immediately, or is this, again, that 10-year plan a dynamic number?
It's a dynamic number.
And explain that to the jury in terms of the challenges, the decades, if you will, of life that Maya, in your opinion, will start having the challenges that make this more and more likely to be needed.
I think Mr. Trump touched upon this. Early on, where Maya is right now, she's in her 20s, and her defenses are pretty good, despite what's happened to her.
About to be in her 20s. I think she's still 17.
Okay, I'm sorry, she's about to be in her 20s.
That's what you had in your book.
As she approaches, excuse me, I stand corrected, as she approaches her 30s, and Mr. Tremp talked about this, that's where life starts to get a little bit tougher in many ways. Jobs and family and just things, we call them stressors. And so with CRPS, or complex regional pain syndrome, I know from my training, education, experience, and knowledge, that's where things start to get really difficult. And so when it talks about the dynamic aspect of this, she's actually doing pretty good right now. But when I spoke to her doctors, we get really one opportunity to educate you, the trier of fact, as to what she's going to need in her lifetime. And we can't speculate. We're not allowed to speculate. So all of these opinions from her doctors are within a reasonable degree of medical certainty and probability. That's why it's dynamic, because we know that as she gets older, the flare-ups and those kind of things are going to happen
In other words,
within a reasonable degree of certainty.
as life takes more bites out of her, it's more likely these will flare up.
Well said.
Is it? Okay. And so you have them in 10-year increments, so the jury could decide when, based on all the evidence, this would begin, in
Yes.
other words,
Yes.
and then apply them to 10-year.
Well,
Is
for
that how it
instance,
works?
you're bringing up the 10 years. It says a physical therapy evaluation, not treatment, physical therapy evaluation, one time a year for 10 years. That just means over her entire life expectancy, 10 years of that, she's going to have 10 evaluations. It's probably not going to be in the first 10 years from now, 10 years from now. It's more likely to be in the middle or the latter part of her life. That's where she's going to need it.
Right.
That's what we mean by that.
All right, and then I think you went through, or are we at now psychological counseling? Did you hit
So-
that yet?
We are at the second category of care, projected therapeutic modalities. What we mean by that is therapy. And so the first item is psychological counseling, and that is one time per week for 48 weeks out of a year. And so Dr. Brewerton and Dr. Wassenaar provided the foundation and the basis for that. The second item is TMS, transcranial magnetic stimulation therapy. 30 to 35 sessions, 2 to 3 times over her lifetime. Dr. Brewerton gave that opinion. My job was to calculate the cost.
What is
Third-
it for? It's for treatment of depression? Is that for the depression?
Absolutely.
How does that work, by the way?
There's a device which is placed on the outside of the head, and it's a very strong magnet, and it's been shown, the data is irrefutable, that that treats depression in a very safe manner. It's called transcranial magnetic stimulation.
No meds,
No meds, no invasive procedure.
okay?
The third item is outpatient psychological care following inpatient hospitalization. Dr. Brewerton said 2 times per week for 30 to 60 days following any inpatient hospitalization. He said it'll be between 60 and 120 sessions in addition to the counseling already outlined 2 times in her lifetime. And I provided the cost for that. The last item in this category of projected therapy is residential psychiatric treatment. So 30 to 60 days, 1 to 2 times in her lifetime. Here again, is that likely, is it more likely to be now, or is it more likely to be towards the middle to latter part of her life when she has life stresses? The latter. It's going to be to the middle to latter part of her life when she has life stresses. And Dr. Brewerton provided that foundation.
Is it, to your knowledge, is CRPS and is the latest thinking that CRPS is an immunities-based disease? In part?
Yes. It's unclear, but that's the thinking, yes.
So what is the influence, if you will, of our immune system as we get older, out of our peak years, if you will, on this?
The immune system is going to get weaker as we get older. That's just a fact. And so that's why you tend to have more flare-ups when you have CRPS as you get older.
Right.
Okay.
Okay.
The
next one.
category,
Now
there are
what?
only 6. We're on number 3.
Okay.
The next category is medications. And what Dr. Brewerton did here is he said, let's have an allowance. So in order to treat her depression and insomnia, there's an annual allowance of $307 a year for her medications. Again, this is very conservative, but we took a very conservative approach. So $307 per unit, or $3,684. And then I list all of the medications that Dr. Brewerton was referring to. So there's only one item in that category, medications. It's an allowance of $3,684 per year.
Doctor, you're familiar with Dr. Brewerton's background, training, and experience as a pediatric psychiatrist?
Yes.
Is his information the type of data that you traditionally rely upon or reasonably rely upon in your profession as a physiatrist life care planner?
Absolutely. And not only did he give me his opinions in writing and verbally, but he sent me an email with a large number of peer-reviewed articles that supported every single thing he said.
And as to Dr. Kirkpatrick, are you familiar with his background, training, and experience?
Very much so.
And is his opinions about the need for different therapies and medications the type of information that experts within your specialty of physiatry and life care planning rely upon routinely?
Absolutely.
All right, let's go to are we done here with the medications? Are we still going on that?
We are. No, we're on the fourth category now.
Yay.
We're landing the plane. The fourth category is home care or facility care, and there are 4 items in this category. The first one, there's a worst case scenario. So this is option 1, private hire of a home health aide. And what Dr. Kirkpatrick said is 24 hours per day, that's 8,760 hours per year for 10 years of her life. And again, this is not likely to be now. It's not likely to be the next 10 years. It's likely to be the middle to the latter part of her life. The next item, worst case scenario, option 1, private hire, homemaker and housekeeper, not a home health aide, homemaker and housekeeper. 4 hours per week. There's 208 hours, there's 168 hours in a week, but 4 hours of help per week, or 208 hours out of a year. And I provided the cost for that.
And what's the next one? 'Cause we're almost
The
done.
next item, worst case scenario, option 2, agency hire as opposed to private hire. The difference there is when it's private hire, you have to take out taxes. You have to worry about when people don't show up. You have to be an agency. Agency hire is a little bit more expensive, but it's easier because you call an agency, and if someone doesn't show up, they send another person. So agency hire of a home health aide, 24 hours per day, for 10 years of her life, not the first 10 years, but somewhere in the middle or latter 10 years, 10 years out of her entire lifetime. And then the fourth item is worst case scenario, option 2, agency hire of a homemaker or housekeeper, 4 hours per week. And I provided the cost.
Okay, let's turn to the last one.
We're now on the 5th category.
Yay, yeah, that's good.
We call this future medical care routine, and Dr. Wassenaar, Dr. Brewerton, Dr. Kirkpatrick all gave me these opinions, and I calculated the cost. So first one is internal medicine, 1 to 2 times per year. The second one is a psychiatrist, 1 time per month. Third one is a pain management specialist, 1 time every 3 months. The fourth one, best case scenario, ketamine infusions, 1 to 2 infusion sessions per year. Each infusion session consists of 4 days of infusion. And this is for the treatment of her complex regional pain syndrome. And these opinions were provided by Dr. Wassenaar, Brewerton, Kirkpatrick. And then the very last item here under future medical care routine is worst case scenario, ketamine infusions, 5 infusion sessions per year. Infusion sessions again last 4 days.
Isn't that dependent on getting Maya to actually do that?
Yes, sir.
So that one may not work out?
Yes, sir.
I'll try. All right. And then I think you've got a last one under future medical care aggressive treatment.
That's correct. So the very
What is that?
last category, we have one item here. And Dr. Brewerton provided this. Inpatient behavioral health hospitalization, 7 days of inpatient care 2 times over her entire lifetime. And I provided the cost for that.
Okay. And all of those add up to the numbers that you, strike that, are all of those recommendations based upon your background, training, and experience and to a reasonable medical probability.
They're based on a lot more than my background, education, training experience. They're the basis, the foundation is, of course, what you just said, but all of the medical records, all of the factual information, all of the records are reviewed, all of the input from our treating physicians and the multiple telemedicine visits that I had.
And then those numbers all went into the final numbers you delivered first?
Yes.
And have those then been provided to the jury through the present value by Christy Kirby?
Yes.
Okay. You're a witness.
Good afternoon, late afternoon, Doctor. How are you
Good late
today?
afternoon to you.
Just to try to get through this since it's a little late in the day. So you're not providing any standard of care opinions, correct?
That's a correct statement. I am not.
Okay, so you're not here to tell the jury that All Children's Hospital did anything wrong, true?
I have offered no opinion about that, and I'm not here to offer those opinions.
Okay. CRPS is a lifetime incurable condition, true?
It is.
And regardless of whether Maya Kowalski ever came to All Children's Hospital, she was going to need future care for her CRPS, true?
Well, that would cause me to speculate, and I would prefer not to, because you're asking me to assume facts that are not, you're asking me to assume something that's not in evidence. You're asking me to say, what would Maya Kowalski have needed but for the trauma she sustained? And I can't do that. That's speculative. What I can say is based upon everything I've reviewed and what her doctors have told me is what does she need as a result of the trauma she sustained. I cannot say what she would have needed but for the trauma, because that would cause me to speculate.
Gotcha. So in terms of what Maya Kowalski was going to need, irrespective of her encountering All Children's Hospital in October 2016, you have not developed an opinion, true?
I have no opinions about that.
Okay. And just to clarify, whether Maya Kowalski was going to need attendant care, regardless of her treatment at All Children's Hospital, you're not making that determination. You're only making a determination of what her needs are now.
I have no opinion about that. That's correct.
And same question with regard to her psychological needs. You're not making a determination of what she needs, but for the treatment of All Children's. This is just what she needs now, true?
Correct. I can't speculate about what she might have needed or would have needed if this didn't happen. I would have to speculate to do that, and I'm not willing to do that.
Okay, so let's talk a little bit about her, just a couple categories of treatment. Well, so for example, when I'm looking at your categories, you've got this in your plan, it's under the home care, facility care again. You've got this,
What page you on?
it's on page 6 of my report, Doctor.
So I have a 10-page report, and I'll go to page 6, and it starts with the home care, facility care category, category 4.
Yeah, it just says the purpose there is to provide one-on-one care and supervision during periods of intense pain due to CRPS, right?
Yes, Counselor, that's correct.
Okay, so let's talk a little bit about, you are aware you don't prescribe ketamine.
I refer and have referred patients to Dr. Hanna, Dr. Spiegel, and Dr. Kirkpatrick. I am a prescribing physician, but ketamine is a unique compound, and I send patients that require that level of treatment to experts in the field. And so I send patients to Dr. Kirkpatrick for that. I send patients to Dr. Hanna for that. I have a DEA license. It's a federal license. Not all physicians have that. I'm a prescribing physician. That means I could prescribe even controlled substances. So I can certainly prescribe and even administer ketamine, but I don't, because I don't do that on a day-to-day basis. Those doctors do, and they're known for that.
Right, and just to be clear, one of the reasons why you don't prescribe ketamine is you have to be cautious with a drug like that, fair?
You have to be cautious with any drug you put in your body, even aspirin.
Well, you have to be cautious with that class of drugs.
You have to be cautious with every drug you put in your body.
Well, there are potential side effects of ketamine that you know about.
There's potential side effects with every drug you put in your body.
Well, you told me the potential side effects of ketamine include dependency, true?
I'm not an expert on the potential side effects. Those are things that I wouldn't rely on my memory. I would look up. So we can look that up, and I'm sure there's a long list of potential side effects. And there's no reason for me to rely on my memory. It's not a memory test. I would simply look those things up, and I'm quite sure it's a very long list of things.
Right. Well, when I deposed you a year ago in 2022, you told me that ketamine is a class of drugs that can affect every organ in the body in an adverse way. Is that?
If I said that under oath, then that's what I said under oath.
Gotcha. And it's a class of drugs when mixed with other drugs can be responsible for stopping breathing. True?
If I said that under oath, then I said that under oath, and that's true.
Okay. In terms of the ketamine recommendations in your report,
Well, just to be clear, those recommendations come from our treating physicians. They don't come from me.
yeah, I appreciate you saying that. That probably is something I was going to clarify with you. And feel free, doctor, to turn to that page of your report where the ketamine recommendations come
Which
from.
page?
Well, we may be on different page numbers, but I think I'm looking at the.
My page of medications is page 5. But are you talking about the infusions? That's a different page.
Yeah, it's under the Life Care Plan for Future Medical Care Routine.
Okay, let me get to that page. The first place where we talk about infusions, because that's what Dr. Kirkpatrick gave me. I believe the first place that shows up is item number 17 on page 8. Is that what you have?
Yeah, it is. We're on the same page.
We're on the same page.
Perfect. Okay. And the reason I wanted to clarify, you had talked about there's recommendations on this page from Dr. Wassenaar, Dr. Brewington, Dr. Kirkpatrick, but the recommendation for ketamine is only from Dr. Kirkpatrick.
True.
Okay. And not to beat a dead horse, although I probably have, you're not endorsing whether that's right or wrong. You're just deferring to Dr. Kirkpatrick on that. Fair?
I was not asked to come here today and give my own medical opinions about these things.
Okay.
These are her treating physician's opinions. My job was to put them in an understandable, readable format and attach the costs over her lifetime, and that's what I did.
Dr. Kirkpatrick told you that his recommendation is to start ketamine now for a total of between $12,000 to $24,000 a year, potentially for the rest of Maya's life.
Correct.
And so just so this jury understands, and they heard from Ms. Kirby earlier that those numbers totaled up to $5 million. That recommendation is for Dr. Kirkpatrick, for him to provide that therapy, $5 million worth potentially. Fair?
So let me make sure I understand what you're asking me. So let me be clear about what I know for sure. Dr. Kirkpatrick told me regarding the ketamine, that falls under the future medical care routine category. He said best case scenario, 1 to 2 infusion sessions per year. And an infusion session consists of 4 days of infusion. Worst case scenario, 5 infusion sessions per year. Again, 4 days. He gave me a cost. It is $12,000 per unit or $12,000 to $24,000 per year for the best case scenario. For the worst case scenario, and again, it's simple math, is $12,000 to $60,000. Now, Ms. Kirby takes those numbers and does her calculations. It's what economists do. These are in today's dollars, not projecting out how much money or resources you need today, if invested, to have it over your lifetime. So those are the facts.
Right. And so when you spoke to Dr. Kirkpatrick and he said, I'm recommending that Maya pay me, starting now, $12,000 for these infusions, did you ask him what's your profit margin on that?
First of all, he didn't say that. He didn't say I'm recommending Maya pay me. The question to him was, Dr. Kirkpatrick, I've been asked to put together a life care plan. Can you tell me within a reasonable degree of medical certainty and probability what Maya Kowalski, your patient, needs and will need over her lifetime? And he did that. And then I asked him, do you have an opinion as to what these things cost. And that's what he gave me.
Gotcha. So Dr. Kirkpatrick told you that his cost to do this, that he's recommending to this jury, is $12,000 a year on the low end and up to $60,000 a year on the high end for ketamine per year.
Well, he didn't say cost. He said that's what the charge is. So I used the word, that's what these things cost. He didn't say that's what his cost is. Those are very different terms. I asked him, what is the cost?
Gotcha.
And these are his charges.
Yeah, totally fair. I'm using terms sort of loosely. What ketamine actually costs isn't what Dr. Kirkpatrick told you. He said, here's what I charge for it.
I have no opinion about that.
Okay. And would you dispute if Ms. Kirby had testified to this jury that if they took the higher end of what Dr. Kirkpatrick said needs to be ketamine, starting today, ending at age 80 for Maya, that cost would be $5.3 million in ketamine? Any reason to
Do the math.
dispute?
If at the worst case scenario, $60,000 per year, if you take $60,000 times, what was it, 63 years?
Yeah, let's say 63 years.
It's $3.7 million.
Okay. Her growth rate's up. So 3.7 million in total dollars for Dr. Kirkpatrick's ketamine, and then the growth rate on that, depending on the +1, -1, could get up to $5.3 million in present value. That's what Dr. Kirby told us.
Above my pay grade.
Okay.
I don't do that. I give things in just real concrete terms. This is what it is in today's dollars.
Gotcha.
That's why economists do what they do.
Okay. $3.7 million in ketamine in today's dollars, but how that projects in the future, you defer.
I defer that to Ms. Kirby.
Gotcha. One moment, please. Thank you for your time, Doctor.
You're welcome, Counselor.
Mr. Anderson.
No need. Done.
Members of the jury. Just the one or anyone else? Okay, can I see the attorneys, please? It was a quick one. Okay, Doctor, the jury had a question on the cost you gave us. Have you taken consideration the cost of doctor-therapist medication as time goes on, prices go up?
That's what Ms. Kirby did. I gave numbers that are based on cost research following a methodology that I must adhere to in today's dollars. Ms. Kirby then takes that and adjusts it to what they call present value. So the numbers I gave do not take into account the likelihood that things are going to go up and not down. She accounts for that.
Thank you. Any follow-up questions, Mr. Anderson?
No, thank you, Your Honor.
Jury, any further questions? Okay, may this witness be excused?
Yes, Your Honor.
Yes, Your Honor.
Okay, sir, you're free to go.
Thank you.
Can I see the attorneys for just a moment, please?
Members of the jury, I was doing my best to run this up to 5 o'clock for you. Just because I like talking slow. That ends your day today. Thank you very much for your time. 9 a.m. tomorrow for them to be ready. Not tomorrow, sorry.
Talk about scary.
On Monday, 9 a.m. on Monday. So if they could be ready at 9 a.m. Have a wonderful weekend. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Thank you. Thank you. Oh, you're welcome. Okay, the jury is out of our presence. Just so everybody in the gallery is aware, we're going to be going through a lot of different things. So why don't we take a 5-minute break? Anyone that wants to leave, great. But then we're going to power through and do as much as we can before we leave this afternoon. So let's take a 5-minute break and then we'll be right back.
shot clock here. Okay, today the plaintiffs consumed 3 hours, 20 minutes for a running total of 43 hours, 35 minutes. The defense today consumed 1 hour, 5 minutes for a running total of 14 hours, 45 minutes. Okay, let's go through. There's a number of issues. Let's just start with evidence and power through and try to finish it. Obviously, those two that I got the paper copies for, we'll have to do those on Monday, but let's try to finish everything else.
Thank you, Your Honor. I've narrowed our list to 4 additional exhibits we'd like to discuss. I'd like to begin with, and then the motion for reconsideration, so that'd be fine. 2277, which is again the risk management file, and page 253.
Let's put it up, please. For what purpose are you seeking to introduce this?
This is a letter to the treating psychologist at Johns Hopkins All Children's Hospital, and the focus of it is notice to the hospital that Maya, through her father, had reported that Miss Beatty was counseling the child in an inappropriate manner, that she was supervising the calls contrary to court order, and that was impacting the mother and the child. So we believe it's relevant to the issues that have been raised through the case thus far. And just, if I may add to that, to orient the court, this is a November 18th letter, and the order in effect at the time was the November 10th order, authorizing only the guardian ad litem or the case manager to supervise those calls.
Judge, I think this clearly is involving the DCF hearing. It's by an attorney representing the Kowalskis in the DCF matter. It's hearsay within hearsay. It's her saying what Jack told her that Maya told him. I believe it should be inadmissible. It's not even Jack saying what, it's her saying, Jack told me. I mean, it's her interpretation of a court order as an attorney representing the Kowalskis.
Again, I need to remind you that no one's allowed to use a cell phone, no one's allowed to videotape this unless you're a member of the credentialed media. So I've asked the court deputies to make sure that that doesn't happen. So I expect that we follow that. Okay, Ms. Crowell, let's go back to you.
Judge, this was a matter that clearly was being handled in the dependency court by virtue, strongest evidence being an attorney representing the Kowalskis in the dependency court are interjecting themselves into something that they believe they needed to address in the dependency court.
Mr. Whitney, I agree with Ms. Crows. Obviously, this is hearsay. I don't see an exception to hearsay that admits this document, with the only possible exception being the one sentence that says some concerns have arisen, and only that sentence. So,
And we're fine with that because that is a statement for purposes of medical treatment. Child is a minor at the time, so it's through her representative. We don't, Mr. Anderson points out, we're also not wedded to having the letterhead that this is from Deborah Salisbury. We care that the addressee is a treating psychologist at the hospital, and it goes to our medical malpractice claim, negligent training claim.
Judge, there's no medical malpractice against Kathy Beatty.
The medical malpractice claim it assumes that all of these actors were agents of the hospital, so it's to all of them, and that was stipulated too.
Judge, trying to siphon off one sentence in a letter that is clearly dealing with the dependency act.
I agree with you. This, I don't think I'm going to be able to just leave one sentence in there. The court will exclude Exhibit 2277-253. What's next?
That narrows our list further. I'm not going to try the other letter, and so we'll go to 2277-286 to 288.
286 to 288.
And you'll see another policy here, Johns Hopkins Children's Hospital, in effect at the time.
So this is the complaint procedure for patients and family members?
Yes, Your Honor.
What's the objection to this?
Judge, can we put this in the category for Monday? As far as policy and procedure?
How many pages is this?
Only two, Your Honor.
I'm sorry, 22 pages?
Two.
Why don't you print it out and I'll take it with the others, but, I mean, this one seems almost like a no-brainer though.
I appreciate that, Judge. It's just late, and if that's okay, if it's, we'd like to do that.
I will defer on that one, Ms. Croels.
Thank you.
What's next?
And then finally, pages 319 to 320. It's again a two-page policy. This time, it's
Back to the Patient's Bill of Rights.
Yes, Your Honor. This is the this is the hospital policy. We've seen the Patient Bill of Rights. I acknowledge that. This policy points out that all patients and families will be informed of their rights and responsibilities, and that the parent and legal guardian, patient and legal guardian will be provided with a current version of the patient's Bill of Rights and responsibilities.
Judges, I don't think it's relevant. They already put the patient Bill of Rights in evidence. It's not like they're saying they don't have the Bill of Rights, so I'm not clear why this is relevant. In fact, they asked Mr. Qual. No.
This seems to, again, this one kind of seems like in the no-brainer. So I'm going to admit 2277-319 and 320. What's next, Mr. Whitney?
Your Honor, that completes our exhibit list as provided today. with the exception of the motion for reconsideration on the Beatty email.
Am I gonna receive a whole bunch of exhibits on Monday?
I do not think so. We'd like to reserve to take a look over the weekend, but should be less than a handful, less than 5 if we find any that we have failed to admit.
And Judge, the drill is we look over our elements and look over our proof and over the weekend, and so the only thing I foresee is plugging any holes.
Okay. Let's move on to your motion for reconsideration. Which DIN number? Is that 3466?
Plaintiff's motion for reconsideration regarding admission of plaintiff's trial exhibit 2123-610, and I apologize, I don't have a DIN on this document.
It's 3466, Madam Clerk. We're on DIN 3466.
I'm sorry, what's the exhibit we're reconsidering?
The exhibit number is 213-610. So that's one page. So can someone put that back up for me, please?
Beatty email.
Go ahead and give me your best shot.
Oh, do you want to take it?
Yeah, Judge, you heard the conversation that is being recited here by Ms. Beatty in the November 29th, 2016 memo. We were trying to move into evidence. And in this email, she purports to describe that particular conversation. And other than Beata Kowalski stating, well, you don't live in a prison camp, you don't live in a concentration camp, or words to that effect, Beata Kowalski was perfectly polite and stayed within the rules. And yet Ms. Beatty writes here to DCF and talks about things that simply never happened. It's a complete fabrication. Well, most of it is a complete fabrication. And so we want to put it in to demonstrate that at that time, Ms. Beatty was not only did not have authority based on the November 10th order, but Ms. Beatty was directly misrepresenting not only to DCF, but to my families and the Sarasota.org outside contractors, that Beata Kowalski was doing things she simply was not doing. Anybody who listened to that tape, that audio, and then compares this, it's just ridiculous. And so we believe that it is probative of the hospital's complete and utter lack of supervision and complete and utter lack of training. I don't worry about the supervision anymore, but complete and utter lack of training, and goes to our medical, our tortious, where's my brain? Our intentional infliction of emotional distress count. And so, and counts 21A through C. So this is, for Ms. Beatty, also a present recollection recorded. If that is indeed her recollection, there's something very wrong with this picture, because we have in writing what it is. Also, we want to, move under 90.105(2), and relevancy of evidence depends on the existence of a preliminary fact. The court shall admit the proffered evidence when there's prima facie evidence sufficient to support a finding of the preliminary fact. And the court had a dialogue with us over the admissibility of it. And frankly, at that point, I thought the court was going to admit it. However, the court was concerned as to whether Ms. Beatty had the authority to do this. And then it turned out that based on the November 10th order, Ms. Beatty absolutely did not have authority on that. And then the court heard, and I should be able to cite the court to the exhibit number of the audio, but the court heard that audio call with Ms. Beatty's reinteract. And so this would be used in conjunction with that, and therefore we believe it's probative of issues in the case. And Ms. Beatty had absolutely no right to be making these comments,
First of all,
because she
Judge,
shouldn't have been on there.
I'm sorry, while you're done. The audio that was played for the court is a November 15th call. This is referencing a call on November 29th. There's been no audio of this call put in evidence or heard by the court. For them to stand here and say that this misrepresents the call, there's no evidence supporting that. The only call that's been put in evidence is from November 15th. This is referencing a call on November 29th. So the redirect that they're referencing, which, by the way, wasn't Miss Beatty, which we advised them of, and they went on and put two witnesses on to say it was Miss Beatty. It wasn't. It's Miss Laporte. Has nothing to do with this document.
Well, I'm not reconsidering my ruling. I remain convinced that this document should not come into evidence. This document is a request from the hospital to DCF and ultimately the dependency court to change the court order with respect to supervision and whatnot. I do not read this letter as any sort of admission that there was no authority, or it doesn't go to the question of whether DCF had delegated or didn't delegate anything to the hospital or Ms. Beatty. So I'm going to continue its exclusion. I will deny the motion for reconsideration, which is at 3466. I'm not going to do a standalone order just orally in court, and then the court minutes will reflect my ruling on that. Okay. I've got some notes on some other things. I see there's Madam Clerk, DIN 3489. And for the court reporter, DIN is docket identification number. So DIN 3489, defendant's motion for entry of order authorizing guardian ad litem and Department of Children and Families to disclose and testify about confidential information at trial. So who from Mr. Hughes?
Yes, Your Honor. You may recall we filed a very similar motion back when several of these individuals with the guardian ad litem and DCF were to be deposed, and DCF specifically requested that we have the entry of this order or this motion in order reflecting the same when we did depositions. They've now circled back and requested the same to testify at trial. In the past, the guardian ad litem's office has also requested these types of orders, and while the guardian ad litem office has not specifically made that request here, the DCF has, and so we'd like to just have an order, which I did attach a draft order as Exhibit A, that tracks very, very closely, if not plagiarizes what we did previously when we did depositions. This is just really to kind of touch all of our bases and satisfy DCF and their considerable concerns about confidential information under Chapter 39. They're sticklers for this kind of thing, so we were just hoping the court would enter an order to allow these folks to come in and discuss matters.
Now, just because I enter this order is not obviously an authorization that the scope of what is contained in this order is coming into trial.
Understood.
And no attempt is being made here. This is just simply, we're going to stay within the confines the court has directed, but DCF still, if they're going to take the stand and discuss matters, they want an order covering their basis, so to speak.
I thought there is no way that we'll be able to keep this within the guardrails. As I see it here, what they will bring out will require us then to counter that with further memos, and now we will be getting into whether DCF can contradict or whether DCF can expand upon a court order. And clearly, they're not authorized to do so, but in many instances here, the emails demonstrate that's exactly what they were doing. And so DCF did not have the force of law here. Yes, they were in charge of the shelter, but they did not have the force of law the way the court orders did. And I cannot see how, frankly, this won't get into a very confusing dissertation on who controlled what when. And we believe that that is for the court to determine at the time of the jury instructions and the order which defines for the jury what's going on. To us, it's really irrelevant what DCF thought at that time. The only point I can see that them making is coming in and saying either secondhand, or I suppose maybe there's a firsthand, someone there who saw Maya and then said, oh, she seemed to be moving around like me. Well, that doesn't seem to be enough probative value, given all the other testimony, to outweigh the problems with this. And so the court is aware, at the end of all of these memos, there is an email from David Silverstein, a summary of the case in which the final paragraph is, in essence, we were wrong, forget it. And I intend to use that if they try to bring any of these in. And so that, I think, I can't understand why they would want to have this, but I seriously doubt how they can keep this from going far outside the bounds and confusing the jury.
Well, I trust in your ability to stand up and say object. And I also trust in my abilities to rule consistently to what we've been doing. I see this as nothing more than a comfort order for DCF and the individuals, just like how I like getting a comfort order from the bankruptcy court whenever there's a bankruptcy and a foreclosure action and I'm being asked to do something, which might otherwise run afoul of some sort of provision of the law. So I'm fine with signing the comfort order with the understanding that it is not an authorization to change how I have been ruling on what is and is not admissible. So Mr. Hughes, can your team print up a paper order? I will sign it right here. I'll hand it to the clerk and they can scan it and you can grab it hopefully tonight, maybe tomorrow. So you'll be able to put it tonight.
Take us just a second.
If we can have it by 5:30, the clerk can process it with a date today. If not, it won't be processed until Monday.
They're not going to testify till Tuesday, Judge, so
If you can get it to me by 5:30,
we'll work on it.
the clerk will be able to process it today.
We're working on it, so.
Have it to you in a couple minutes, Judge.
And so I trust then, will the order then reflect the court's instruction here that the defense is not allowed to exceed the bounds the court has previously set forth to all
The
counsel?
written order doesn't have that. However, my statement here, I think, is clear enough.
It is, Judge, and I was going to ask for some guidance anyway with respect to these witnesses, either now or Monday, on that issue.
We're talking about it, so let's.
Well, here's well, because the testimony from the Kowalskis and others mostly Kowalskis, have been that they were prevented from bringing in communion. They were prevented from various things. And in fact, those came from DCF. DCF is the one that told them, no, they can't have communion, or no, they can't do this. They have asserted in front of this jury that Johns Hopkins prevented them from bringing communion in, prevented the priest from seeing her, all of the things that they allege we haven't prevented. Additionally, they have played an audio in front of this jury and had two witnesses say it was Kathy Beatty when it's Charlotte Laporte on the audio. We told them that. They went ahead with it anyway. Miss Laporte is coming in Tuesday morning, and she will testify. That is my voice on the audio redirecting Miss Kowalski. So those are the general parameters of why we're calling the specific DCF people.
Okay. Go ahead, Mr. Anderson.
And there lies the problem. Virtually every one of these directives that they intend to bring before the court was started, promoted, and requested by Johns Hopkins. DCF did not hang around that hospital to watch how things were going. DCF did not go and test a bunch of the baked goods. DCF wasn't there to look at all of the, quote, religious artifacts. Every single thing that they're talking about, there is contact between Johns Hopkins and DCF where they're saying, hey, this is what that bad girl's doing. This is what that bad mom's doing. We need an order to be able to do that. And if they're going to come in and somebody's going to testify to that, I want the ability to go after them and say, you didn't see it. You didn't do it. You were following their commands. And so as long as I have some freedom to go after them in that way and point out these emails, then, all right, they can try at it. And then I'm going to certainly bring in that last email which says, oh, well, never mind. All of this was, we had no basis.
On the question of the audio that has already been played for the jury, that the plaintiff contends is Miss Beatty and the defense claims is Charlotte Laporte, I have no problem with Charlotte Laporte coming in and identifying her voice and saying it was her. That's an easy issue. The question about can DCF, I keep wanting to call them HRS, but can DCF testify that they instructed the hospital XYZ? Assuming that there was a court order in existence on that specific day that authorized DCF to supervise the visits, and DCF was then instructing the hospital as to the parameters, then the answer is the defendants will be able to do it. That does not open the door to the dependency action, nor does it open up this concept that, well, it was really the genesis of this was the hospital. The hospital, if they were asking the court or DCF, that's where they needed to go. That's part of the 39, and that's what they had to do. So, does that then answer
that
that
helps.
question?
I believe so, Judge.
Let me see that order so I can get the clerks working on this.
This was Exhibit A to the motion we filed.
What we would need then, Your Honor, is a proffer on these because it seems to me to be completely unfair in order to allow them to put in an email or memo from DCF and then leave the chain that started it out. And so if there was no order preceding it that said, okay, the court finds that you need to go and take all the baked goods out of there, I don't believe it's fair then to have DCF come in and say, oh yeah, we were in control of all this, when in fact they did not have judicial authority to do so. And second, if there was a delegation of some kind, it still had to stay within the bounds of the order, and Johns Hopkins' behavior had to stay within the bounds of its own rules and regulations, which to me opens that up significantly.
Well, I feel like I've been doing proffers. I will not deny anybody if they feel they need to proffer something. You'll get an opportunity to proffer. If we need to do it before, we'll try to do it before. So I don't know what else to say. If you want to proffer, happy. That's
My concern is
my job. I'll accept the proffer.
Yes, sir. My concern is this. In the heat of cross-examining some of these folks who are adamantly in support of Johns Hopkins and work hand in glove with Johns Hopkins through this whole thing, I would like to have enough leeway to point out things like that so that simply because it's DCF, a government agency, that they somehow have a halo around them of all of their actions. The only thing that has a halo around it are the actions of the court. And so I hope and pray that the court will allow me to cross-examine them about the circumstances giving rise to this where there is no direct court order that says they must do it.
Well, I think we're now into the hypothetical realm. I've told you my thoughts on what Ms. Crowell's specific request was. And, if there is a specific issue on a specific piece of paper, we can address it at that time. But your statement that to give you a little leeway seems to be a very dangerous statement for me to make, because I don't know what that means.
Yes, sir. I understand it'll be topic specific.
What's, let's see, so we dealt with Ms. Kroll, was there anything else relative to the general DCF order issue that we were talking about?
Can I have 1 second?
Sure.
No, Your Honor. I think we're fine.
And also, Judge, I may want to revisit any ruling on at least the Florida Constitution to the extent that DCF starts acting in a manner completely inconsistent with the Florida Constitution. But I guess that's fact specific.
You know, let me just,
Are really going to come in and testify that DCF ordered that she not be able to see her priest?
I'm not going to get into an argument with you.
I'm not going there.
Thank you.
Okay, next. So we dealt with the evidence. Are there any deposition designations for me over the weekend?
Judge, here's what's going on. Oh, do you want to do it? Here's what's going on with the deposition designations. The court has previously ruled on most of them with objections. We're going through and streamlining them. I don't think that's going to involve the court because we're just actually reducing what we want to read in, and the court has already ruled on those objections for the depositions that are going in on Monday. We do have a couple of witnesses that we now believe we're going to have to do by deposition, so there are going to be a couple of additional depositions. They won't be, I don't believe they'll be long, but we need to do a couple of witnesses by dep, we believe now.
And so when would I anticipate receiving the designations?
Well, we're going to try to get them, we're working on them this weekend, but.
We're trying to retool them to,
Yeah,
Bring
the
it
new
down?
ones, the new ones.
or the new ones. I don't think we have any new ones this weekend.
It will be played very soon, I think.
Well, there'll be at least one,
Not necessarily Monday.
but it will be brief.
Judge, I guess,
When do you want them? I guess that's.
well, our focus, Judge, was tooling down the ones that we're going to play on Monday, and that's going to take a little bit of time. So it'd be hard, plus we have to get them over to the other side on the new ones, and they have to do their counters. So I doubt you'll get them this weekend, Judge. If that makes sense.
That's fine.
It will be all depositions on Monday?
Yes.
Yes.
And can you tell them what depots you are contemplating on playing on Monday?
Yes, sir.
We have not told them.
We have not told them, but we
Now,
will.
I'm asking you to go ahead and tell them.
Yes.
Oh, okay.
What depended on which ones we got streamlined, but we were looking at in general, the Tampa General and the Lori depositions, and somebody else is better prepared to give you the names.
The lead off will probably be Dr. Behar Posey. She's probably, hopefully by the time we get through, in less than an hour. Then there'll be Dr. Lewis, who will be about an hour, give or take, at least as far as we're concerned. Then there will be a deposition, a designation of Dr. Hannah that we will need to.
What about race? We're not doing Hannah Monday, are we?
Thinking about.
Hannah Monday?
Dr. Malik is one that we've
Dr. Malik?
anticipated.
We're trying to go chronologically. So it'd probably be, what we're thinking is we probably have Monday afternoon to fill. And in that respect, we'd have Dr. Posey, Dr. Lewis, and Dr. Malik. And perhaps if there's time, that's probably going to shoot it, Judge.
I heard something about trying to change the 4 o'clock to 3 o'clock on Monday.
I think that would be a very good idea. There's an awful lot of counts, the punitive damages. One of these counts is a matter of first impression anywhere, and so we've had several weeks of testimony already. So with our arguments on both sides, I think probably having 2 hours rather than 1 hour, hour and a half, but
Is Mr. Elegant going to be able to be here?
I don't.
He was prepared to be here at 4 o'clock on Monday. I haven't had a chance to check with him as to whether he can be here at 3 o'clock.
And is this something he's going to come live for?
Yes.
If we can just see if Mr. Elliott can be here at 3, I'm fine starting doing them at 3.
Okay.
On Wednesday, I'm thinking we'll probably do 90 minutes on jury instructions. And depending on how others use my time that day, it might not be until 3:30.
Okay, that probably, actually,
It's
that's.
either gonna be like 1:30 to 3:30, but probably on the 3:30
That's a
side.
very good idea, because I'm sure that Mr. Elliott and I are both gonna be wrapped up in TVs for a while, and my game plan is to go back to Tampa on Monday evening, and then try to spend as much time as I can on Tuesday and Wednesday getting ready for that hearing. I told Mr. Elliott that, and I think the two of us hopefully will be able to work together a lot in that time.
What would be really helpful to me is by the time we leave on Tuesday,
For you to have a copy.
whatever agreements or disagreements, wherever we are, to get me that set so I can
I think
spend Tuesday night with it.
I think that's a doable goal.
And I do want to get this instruction crafted about, from this date to this date, who's allowed to supervise and things like that, because, the jury's.
That one you may not see on Tuesday, but I said my efforts to do that so far have proven to be really complicated, because other than reading kind of the instruction, it's almost more difficult to try to lay it out in some other fashion. So I can talk to Mr. Elliott about that as well, as to how he thinks we best explain it as well. It may very well be that trying to at least narrow down the order and the judge provisions of some of the orders. Several of the orders, by the way, especially as to the conversations over the telephone, it's the same thing in 2 or 3 orders with only slight modifications. So we may be able to explain that in some shorter fashion.
Okay. Are there other motions that either side need or want to address today?
I don't think so on our side.
Because what I don't want to have happen is we walk in on Monday morning with, 2 hours worth of motions while the plaintiff's trying to rest, and I've got a jury cooling their jets.
Judge, I discussed one motion we put out last night having to do with the apparent agency claim. I discussed this with counsel. I don't know if you guys just want it. It has to do with a claim that was made by Dr.
Has this been filed yet?
I'm sorry?
Has it been
Probably
filed?
not. It was,
It probably hadn't made the docket yet, Judge. It came in last night. We can do it on Mondays.
Well, I mean, has it been when was it actually filed?
It was filed yesterday evening.
Let's see, because the last motion that was docketed was a motion filed this morning at 9:51, which is motion to allow certain witnesses to appear and testify via Zoom. The motion before that was the DCF motion, which was at October 12th at 10:20 a.m. So there's nothing.
We have a problem, Houston. I'll check on it, Judge. Because my information was that it was filed last night about 8 o'clock, 8:30, something like that. And if it hadn't made the docket,
I will tell you, the clerk would have docketed by then. So either it wasn't filed or it's in the correction queue, but if it was in the correction queue, you would have been notified.
well, we'll figure it out and fix it. But I've advised counsel of what it amounts to. They've told me they don't have.
Since it's not docketed, I won't see it. It won't appear until at least Monday. So can you or somebody send it to that other email address?
Yes, sir.
So I'll be able to look at it over the weekend and actually know what you're talking about.
Yes, sir.
We had in the works, I don't know if we filed it or not, in follow-up to my Ora Tennis motion for amendment or relief for general agency as opposed to just a parent agency. And may we provide it to that email? It's more or less in response to what they're saying.
Okay, well, the answer is yes. Obviously, file it through the e-portal, but then submit it, a copy to that other email address that we have been using. And I'll get a chance to look at it, and that way I'll have some ability.
That's just the other policy, Judge, that
Okay,
you're going to take on.
thank you. Anything else on the horizon?
Not from plaintiffs, well.
Mr. Whitney.
We will be filing a motion regarding limitations on expert testimony, but we don't need to take it up Monday. I don't imagine there'll be,
Yeah, are they gonna
Whoa,
call
whoa,
any
whoa,
experts
whoa.
live?
Yes.
What do you mean, a limitation on expert testimony? Kind of like the same issue we had with Mr. Hunter the other day? I mean, why are we talking about this now as opposed to before trial?
because it's congruent with the court's order entered just before trial, limiting specialists, whether anesthesiologists, pediatricians, or psychiatrists, to testifying only to standard of care in their field.
If we knew who they were gonna call, it would streamline things greatly.
Well, I would just, Mr. Whitney, I would recommend any substantive motion like that get filed sooner as opposed to later. I do not want to get jammed.
We will have it filed this weekend.
Okay. Anything else?
Thank you, Judge.
I will see everybody here 8:30 on Monday. We'll be in recess.
Do the best you can considering all the things.